then in train for the procurement of Typhoon aircraft. The Director of Prosecutions had to then decide, does he succumb to this threat or does he continue with the investigation? And at page 576, you will see what the Director of Prosecutions did, and the similarity to this case will become apparent. At paragraph 22, the Director discussed the matter further with his case team that evening. On the morning of 14 December, he confirmed to the Legal Secretary that his conclusion remained the same, that in his view, continuing the Yamama investigation would risk serious harm to the UK's national and international security. He accordingly decided that the Yamama investigation should be discontinued. His decision was announced in a press release the same day. It read, "The Director of the Serious Fraud Office has decided to discontinue the investigation into the affairs of BAE Systems plc as far as they relate to the Yamama defense contract with the government of Saudi Arabia. This decision has been taken following representations that have been made both to the Attorney General and the Director of the SFO concerning the need to safeguard national and international security. It has been necessary to balance the need to maintain the rule of law against the wider public interest. No weight has been given to commercial interests or to the national economic interest." So there were suggestions that if he did not stop the prosecution and Saudi Arabia withdrew, that that British citizens may lose their lives. That was the perception. Now, it went to the High Court, and the High Court said that he must continue the prosecution, and the House of Lords overruled that. This is what happened. At page 580 is the main issue. It is common ground, paragraph 30, it is common ground in these proceedings that the Director is a public official appointed by the Crown, but independent of it. He is entrusted by Parliament with discretionary powers to investigate suspected offences which reasonably appear to him to involve serious or complex fraud, and to prosecute in such cases. These are powers given to him by Parliament as head of an independent professional service who is subject only to the superintendence of the Attorney General. There's an obvious analogy with the position of the Director of Public Prosecutions. It is accepted that the decisions of the Director are not immune from review by the courts, but authority makes plain that only in highly exceptional cases will the court disturb the decisions of an independent prosecutor. At page 581, against the letter G, towards the bottom, the court said the Attorney General on 13 December 2006 was said to be extremely unhappy at the implications of dropping the investigation at that stage. What determined the decision was the Director's judgment that the public interest in saving British lives outweighed the public interest in pursuing BAE to conviction. And then finally at page 584, the court said, the Director was confronted by an ugly and obviously unwelcome threat. He had to decide what, if anything, he should do. He did not surrender his discretionary power of discretion to any third party, although he did consult the most expert source available to him in the person of the Ambassador, and he did, as he was entitled, if not bound to do, consult the Attorney General, who was, however, properly left the decision to him. The issue in these proceedings is not whether his decision was right or wrong, nor whether the Divisional Court of the House agrees with it, but whether it was a decision which the Director was lawfully entitled to take. Such an approach involves no affront to the rule of law, to which the principles of judicial review give effect. And we rely precisely on that this is his discretion, that is the National Director, and unless there are allegations of that he was mala fide, or that he had an ulterior motive, or that he didn't apply his mind, then his discretion stands, and the court should not impose its own wisdom on what the court would have done or what the court believes was reasonable. And yesterday, our learned friends referred to the...
Must be rational.
Must always be rational.
Pardon?
Must always be rational.
Yes.
But even being unreasonable is not irrational, because one can imagine that in the Corner House case, the House of Lords decision, one can imagine that there were many people in the United Kingdom who are upset that their prosecuting authority succumbed to a threat of this sort. And there were diverse views. But at the end of the day, And it may be that the majority of the people would not have taken the decision which the director of the Serious Fraud Office took. Maybe they would not have, but it was his discretion, and the House of Lords said it should not be interfered with. And yesterday, a learned friend referred to the two-stage test. Firstly, was there an abuse? And secondly, was the nature of such a character that it is sufficiently linked to justify a stay of prosecution? Now, he referred to the Latif case, again in the United Kingdom, and I just want to read from the case which they rely upon. It's in the bundle which they handed up to the court yesterday. It's at page 157. Now, I don't want to read the entire portion to the court because, with respect, your ladyship and your lordships can read it yourself. So if I skip anything, it's only because I understand that it will ultimately be read in full by the court. But starting at page 157, this is what the court said. The court may recall that this was an entrapment case. And during the case, the accused applied for a stay on the basis that there had been an entrapment, and it was refused, and they went on appeal. This is the appeal. In the middle of the page 157, it's page 360 of the judgment. The Court of Appeal rejected the concession of the prosecution and held that the customs officer did not commit an offence under section 170 because he did not act fraudulently. Then the next paragraph. It is now necessary to consider the legal framework in which the issue of abuse of process must be considered. The starting point is that entrapment is not a defence under English law. This, however, is not the end of the matter. Towards the bottom, but 6 lines from the bottom, if the court always refuses to say such proceedings, the perception will be that the court condones criminal conduct and malpractice by law enforcement agencies. That would undermine public confidence in the criminal justice system and bring it into disrepute. On the other hand, if the court were always to stay proceedings in such cases, it would incur the reproach that it is failing to protect the public from serious crime. The weakness of both extreme positions leaves only one principal solution. The court has a discretion. It has to perform a balancing exercise. And in our case, that was the discretion given to the national director. He had to perform a balancing exercise. And over the page, in the middle, just between the letters B and C, Bennett was a case where a stay was appropriate because the defendant had been forcibly abducted and brought to this country to face trial in disregard of extradition laws. The speeches in Bennett conclusively established that proceedings may be stayed in the exercise of the judge's discretion, not only where a fair trial is impossible, but also where it would be contrary to the public interest in the integrity of the criminal justice system that a trial should take place. An infinite variety of cases could arise. General guidance as to how the discretion should be exercised in particular circumstances will not be useful. But it is possible to say that in a case such as the present, the judge must weigh in the balance the public interest in ensuring that those that are charged with grave crime should be tried, and the competing public interest in not conveying the impression that the court will adopt the reproach that the end justifies the means. So, yes, and I'll just point out that in the reasons of Mshe, which I'll come to, that's what he referred to. That's what he relied upon, what I've just read to the court. So, I want to move on then to what was the problem? What was it that McCarthy was doing? What was his role? And I've handed up just a chronology to make this portion of the argument more speedy. There are references to the affidavits. Only in some instances will I need to refer to the affidavits themselves. The chronology is this. On the 1st of November 2007, that's when Dana was present at the meeting between MSHE, the deputies, and McCarthy. And the meeting decided that the decision to prosecute President Zuma should be left to the head of the DSO and the investigating director. If it need be said, he was not the president at that stage. On the 12th of November, MSHE met with his deputies to discuss the prosecution of the third respondent, that's President Zuma. The meeting resolved that McCarthy, together with Ramaiti and Hofmeyr, would meet with the prosecution team to review the case file. MSHE made it clear that it is up to McCarthy to take a final decision to prosecute, and we've referred to where this appears in the affidavits, and where the court will see Annexure WH53, Vili, legal position, NDPP not to make decision. Is NDPP comfortable with the decision? Decision of DSO, that was McCarthy, and NDPP comfortable. That was a note made in the minutes of that meeting, which appears at WH53 at page 373. On the 17th of November, Dana was instructed by McCarthy to finalize the indictment and to include Ngwengwe, he was the investigating director at the DSO, to include him in any future discussions. This is reinforced in Dana's notes. I needn't go there. In November 2007, McCarthy knew that suggestions to delay the prosecution would be rejected. He started lobbying individuals to postpone the prosecution. On the 21st of November, McCarthy tried to persuade Hofmeyr to delay the prosecution. Now, can I ask you to have regard to the answering affidavit at paragraph 164? It's at page... Paragraph 164. It's in volume 3 at page 214. This is what Hofmeyr said in his affidavit, and for purposes of this application, it must be accepted. It was around, it's 164, it was around that time that McCarthy first raised with me the possibility of postponing the prosecution in both the Zuma and Salibi cases. He did it informally, as was his style.
Just a minute, my page 214.
214, paragraph 164.
My paragraph
it's on 217.
217.
217. Paragraph 164 is on 217.
Yes.
Thank you. Somebody's then paginated my name.
That's how we have it here.
Okay.
That is Hofmeyr says, it was around that time that McCarthy first raised with me the possibility of postponing the prosecution in both the the President Zuma and Salibi cases. He did it informally, as was his style. McCarthy tried to persuade me that it was prudent for the NPA to delay the third respondent's prosecution. He also said that he did not believe that the NPA had much of a case against Salibi. I disagreed with him. He told me that it was our duty as senior public servants to assist President Mbeki. In other words, we should do everything we could to ensure that President Mbeki was successful at Polokwane. I objected and our conversation became heated. I told McCarthy that it was our duty in the NPA to remain independent. The nature of our work meant that we sometimes had to take decisions that impacted on senior politicians. We could not allow the NPA to be used as a political instrument. I've been active in the ANC and the United Democratic Front for many years before I joined the NPA. The one thing I know is that in politics the wheel can turn very quickly. Those in power today can easily find themselves out of favor suddenly. I told McCarthy that it would be unconscionable for us to risk the future and independence of the NPA by coming embroiled in factional battles with political parties. I realized then that McCarthy was committed to supporting President Mbeki, whatever the cost to the NPA. Our relationship remained strained after that encounter. I later learned that he had successfully lobbied MSHA and persuaded him that it was necessary to delay the prosecution. If I can go back to our chronology, on the 27th of November, that's when MSHA and the deputies met. There was a briefing by the prosecution team. McCarthy was present, and all was satisfied the prosecution could go ahead. Can I just pause there for a moment? I see that I've overlooked something I wanted to raise, and that is in regard to what I've just read concerning Hofmeyr and McCarthy and their interaction. Again, just to show the court what it was that McCarthy was doing and how he was using his own political agenda and how he was using the NPA as an instrument to achieve his own political agenda. Can I ask the court to refer to just bear with me for a moment. Where's 914A? Volume 10. Volume 10 at page 908. And this is Hully's affidavit, and the document at 908, it's MH7. Is an attachment. It's MH7, page 908. May I proceed?
Yes.
This document at 908 is the special report of the Joint Standing Committee on Intelligence on the Special Browse-Mole report. If I may ask you to return to page 914, 914 at the bottom. It's got, now this is 27 November 2007, you see the date at the bottom. At the same time that all of this was happening. Now come the findings of the JSCI, which says at the very last line, with all the relevant information at the disposal of the JSCI, we came to the following findings. And the first one is, the Browse-Mole report is the product of the DSO. The leadership of the DSO, that's of course McCarthy, particularly the head, authorized the investigation and the production of this intelligence document, which was outside Section 28 of the NPA Act. Accordingly, the production of the Browse-Mole report was illegal. 2. The purpose of the instruction to compile the Browse-Mole report was primarily directed and targeted at gathering information on a known individual. This person was the Deputy President of the ANC, Jacob Zuma. And in paragraph 7, the DSO did not take any remedial or corrective actions after the leak of the Browse-Mole report, despite it being classified as a top secret document. They did not take any action against the senior special investigator from whom the leak originated. They neglected to take action against the illegal activities of those who were involved in the production of the Browse-Mole report. And finally, under recommendations, the executive authority must take appropriate action against the head of the DSO, again McCarthy, and all the officials who were involved in the production of the Browse-Mole report. Now, that was the report of the Joint Standing Committee who made these findings about what it was that McCarthy was up to
But this
at
was
that time.
this was then already available on the 27th of November
Yes, it was.
2007,
Yes,
months before the decision was taken to stop the...
Yes, about 3-4 months before.
Yes. And so what I'm actually getting at, Mr. Mishe at that stage knew about this report and what the findings were?
One assumes he must have been, because he was appointed in September, this is November, and if action must be taken, I would imagine that it was directed to him to take that action.
Was an action taken against McCarthy by Mr. Mche? Papers don't tell us
I'm not
anything.
sure if it's in the papers. I think the papers say, I'm not sure, I think the papers say no action was taken.
Yes.
On the 3rd of December, McCarthy went to see Mche and said that he wanted to talk about postponing the President Zuma prosecution. Mche did not agree with McCarthy that the prosecution should be postponed. He nevertheless accepted that McCarthy had the authority to make the decision. Mche spoke to Don and told him there was a possibility that the prosecution of the President Zuma would only take place the following year. That's 4 December and 6 December. We know that Mche phoned Don and told him he had decided to delay the prosecution, and we went through that yesterday, what his reasons were why he did that, which appears in his supplementary affidavit. The Dana affidavit in volume 33 is relevant in one or two respects. If I could ask the court to refer to volume 33 at paragraph 4. Where's my volume 33? You got it. Volume 33. The Dana affidavit starts at page 3166. Paragraph 4, Dana says, I've read the answering affidavit of William Andrew Hofmeyer. I understand that Hofmeyer's affidavit has already been served and that it is intended that this affidavit will be served subsequently, but to be regarded as having been filed together with therewith. And then he confirms the facts insofar as they relate to him. So it was part, in effect, of the answering affidavit. At paragraphs 6 and 7, Dana says, I confirm that on Friday, 21 December, McCarthy instructed me to round up the prosecution team. This is immediately after Polokwane. I confirm further, McCarthy told me that Mche had instructed him to institute the prosecution. Now, he has to do so immediately. I needn't go there. We went there yesterday, and Mche says that's not true. He was away. He was on leave, and he gave an interview to Radio 702 to say it's going to happen the following year. So that was what McCarthy was telling Dana was certainly not true. Then we know that on the 6th of December there was the memorandum which we went through yesterday from Dana, which I needn't go through again, which he expressed his disquiet and said effectively that this is going to come back to bite us. Again, in December 2007, and Hofmeyer asked Mche how the decision to postpone the prosecution had come about, he confirmed it was McCarthy who persuaded him that it was necessary to postpone the prosecution. He was prepared to support whatever decision McCarthy made. 20 December, that's the Radio 702 interview I've referred to, and 21, I've already referred to that McCarthy gave the go-ahead for the prosecution. Can I come back to the question which was put to me earlier by Justice Ledwaba? Where's this one? Perhaps you would care to make a note, page 264 of Hofmeyer's affidavit. At page 339, Hofmeyer says, in June 2008, Mche wrote to the minister imploring her to take action against McCarthy To my knowledge, the minister did not respond, despite the findings of
I'm
the
not with
JC.
you. Which page are you referring us to?
Page 264, volume 4, at paragraph 339. I hope can I just check that if I may? Our pages now, it seems maybe one or two pages now.
Volume 4 page.
I've got 264, it's paragraph 339.
Page 266.
266. Maybe 266, paragraph
Mine is 266. 339.
Perhaps I should take it from 337. Their report released publicly in November 2007 criticised McCarthy for failing to cooperate fully with the JSCI. 338, on receipt of the JSCI report, the minister wrote to the NPA instructing them to take action against McCarthy and Powell. And Shea had no authority to act against McCarthy, only President Becky had the power to act against him. 339, in June 2008, Shea wrote to the minister imploring her to take action against McCarthy. To my knowledge, the minister did not respond. Despite the findings of the JCI, President Becky failed to take action against McCarthy. And we know that McCarthy resigned shortly after that and went to take up his position as head of integrity at the World Bank.
So in terms of what is stated here, you are saying the head of the NPA could not take steps against him. Say it was only the president and the minister
Against McCarthy.
against McCarthy, right?
Yes. So that's the view that Shea had, that he could not take those steps, that it had to be taken by the president. I would imagine on the basis that he's a presidential appointee. Whether he could internally discipline him, I haven't considered.
Yes.
But the policy and the act of the NPA, what does it say? Does it not give him the powers to institute action against personnel who are within his establishment?
Can I look at that and get back to you?
Yeah, you can get back to us
I don't know
later,
the
yes.
answer.
Yes.
I know that there have been issues within the NPA as to what steps can be taken in terms of the hierarchy, and certainly in terms of Section 12(6) of the NPA Act, when the President can convene an inquiry into the conduct and suspend pending an inquiry.
Okay, you can come back to us later after you have looked into the point.
I want to then go to the recordings, which are set out in the statement of Shea at JS10 in the founding affidavit at page 125. On the 7th of November, there's a recording between McCarthy and eNCA. McCarthy says to him, "I read yesterday's Business Day editorial. You must just read it." And he said,
so it's JS.
Which volume is it in, Mr.
JS10.
It's 125. So page 125.
120, it starts at 120. In fact, it's in the founding affidavit,
Which volume?
B1, 1B. The Lords will recall that they patinated from number 1, starting with the supplementary affidavit, and then the founding affidavit came as a later bundle. These recordings appear in the context of Mshe saying in his media statement, "I will now deal with the contents of some of the recordings set out below. I believe that it is in the public interest to make this available, as this is a matter of huge public interest, and I believe that it is important for members of the public to be able to draw their own conclusions about the nature, I imagine, of conduct." Now, I'm not going to go through every recording. I just want to highlight the following. On the 7th of November, McCarthy says to Ngcuka, "I read yesterday's Business Day editorial. You must just read it." He says, "Just remind me," and McCarthy says, "Yes, it's in line with your thinking." And the comment on the side is that that Business Day editorial expressed the view that it appears to be to the benefit of President Mbeki when Mr. Zuma is not facing charges. Then over the page, on the 26th of November, and Ngcuka says to McCarthy, "So you, the only one who can just save this country from its madness." And about halfway down the page, McCarthy says, "Up until Friday, I received a strong memorandum to say, charge and charge now." Ngcuka, "Friday?" McCarthy, "No, this Friday. The team says we have been messing around with this thing. We're allowing ulterior considerations to come in. It will become an impossibility later. We now must take action and deal with finish and claw, as Jackie Salibi says, but we will talk when I see you." And then at the bottom of the page, on the 12th of December, Ngcuka says, "As long as you don't do it this weekend." McCarthy, "If we hold it back, it will be because the clever people like you and others are saying to us that the country needs cool heads, but I would hate to have to be seen to be wrong later." And Ngcuka says, "Just don't do it this weekend." And it continues, "It might change, Ngcuka. I can't keep an open mind. You can't do it this weekend. Our minds won't change." And then he reiterates, Ngcuka says, "Just don't do it this weekend." And McCarthy says, "I won't move this weekend. If this changes, just let us know." And Ngcuka says it won't change. And then at the bottom of that page 127, 13 December, McCarthy, "What is the mood like?" Ngcuka, "Is it out?" McCarthy, no, I'm just checking the pulse of securities." McCarthy, "I thought I will give you a call once a day, twice a day, to hear whether the position has not changed." And he said that thing will only be filed tomorrow. They were talking about the Constitutional Court. But what he talks about whether the position has changed, and over the page, you'll see in the next block, McCarthy says, President Zuma will say we are conspiring against him. And McCarthy says, "Can I ask, the script has not yet changed?" And Ngcuka says, "Yeah, no." Now I want to then turn to the reasons given by Mshe in this document, and to start off with we know that representations were made. There were written representations followed by oral representations. There were two parts. A briefing was given on the written representations, and the second part was a briefing on the allegations of a political conspiracy. And Hali then disclosed that he was in possession of recordings of conversations, and they also related further examples. They said linked individuals to a conspiracy to discredit President Zuma. And then we know that on the 9th of March, it was Hofmeyr and Mzinyati who listened to the recordings. And they then reported on those contents. And they said, he says in his affidavit, that Hoffman says that they were shocked, he and Mzinyathi were shocked by what they had heard. But it wasn't only they who were shocked. It wasn't only Mshe who was shocked when he listened on the 31st. It was also Downer.
Did Downer listen to the tape?
Did he? I'm told that he did.
When?
Can I just see if it appears in his affidavit? 3181. He says that 3181, it's in volume 33. This is Dana's affidavit. What does he say? Listen.
Is that page?
3181.
3181.
Paragraph 83. I can't recall, my lord, whether it says that he listened to the tapes. But he says at 83, I confirm that we were all shocked about the contents of the recordings as they cast serious doubt on McCarthy's integrity. I was reduced to tears, he says. Notwithstanding the contents of the recordings, the prosecution team remained convinced that President Zuma's representations for the prosecution to be discontinued should have been declined. But it's quite a statement to make when you're implying shock that a person in the position of Dana says that this, when he found out about this, whether he heard it I can't say, when he found out about it, that it reduced him to tears.
And this was the information from Hofmeyer and Mzinyathi, telling them about the contents of the tape. They were all shocked.
Yes, unless he listened to it himself. And I'll look to see whether, I don't recall seeing that he said he listened to it, so I don't know whether he did or
I couldn't
didn't.
pick it up either. That's why I'm asking you this question.
But we will look, and if we find anything about that, we will tell you. But I don't recall seeing it.
You say that Hofmeyer and Mzinyathi listened to the tapes on the 9th of March.
Yes.
And when did they brief the entire team?
Can I just... Where's the affidavit of And it starts, I think it would be page...
Just a minute.
Yeah, proceed.
In volume 3, from paragraph 249, so I think it may be 243 in your bundle.
Volume 3.
Paragraph 249, page 243.
Page
243. Volume 3. Volume. This is where he deals with the recordings from paragraph 249. It says the first meeting took place 18 March.
Just a minute, please. 243, paragraph 249. Yes.
Sorry, it starts actually at paragraph 247, just before that. And Hoffman says, on paragraph 247.2, We met with Hali for a second time on 9 March in my office at the NPA. On this occasion, we were able to listen to the recordings. We made notes of what we heard. Between 18 March, at paragraph 248, between 18 March and 1 April, MSHA consulted extensively with the senior management team and with members of the prosecution team about how to respond to Zuma's representations. Then there's the first meeting on 18 of March. The meeting considered 2 representations. At 252, Mzinyati, paragraph 252, Mzinyati and I reported on the contents of the recordings. There was general agreement that the contents were shocking. If authentic, they cast serious doubt on the integrity of McCarthy.
He does not mention when was this.
No. But it seems that is the meeting on the 18th of March. When
18th of March.
It starts at paragraph 249. There's a heading, 18 March. And
would I be right in when you look at the contents of 248, which says that they consulted extensively with senior management and the team about how to respond to Zuma's representation, that D7 finds relevance in this paragraph. That is how it came about that D7 should be drafted.
Well, D7 just says March, but it could be that it came from that from those discussions. But at that stage, MSHA had not listened to the recordings.
Yes.
He only listened to recordings on the 31st of March.
But they had briefed him about the contents of the recordings.
It seems so. They say so. The 18th of March. I don't know whether the letter
wants to consult with you.
But he says that he consulted extensively with his senior management team and with members of the prosecution team about how to respond. Yes. And then Downer drafted that D7.
Yes.
But that must have been after the 18th of March then.
Yes.
Before the 18th of March.
No. It can't be before the 18th because in D7 they also refer to the contents of the recordings.
If you have a look
it looks like it could have happened after 18th.
Yes, well, if you have a look at the concerns that Downer raised there, I think that must have been then.
That comes out of the meeting of the 18th March. Oh. No. Well, it may not. It may not be as straightforward as that, because if you look at 26253, after Mzinyati and Hofmeyer reported on the contents of the recordings, he says at 253, we were all concerned about the source of the recordings. Hali had refused to disclose where he got them. And 254, it was decided we should ask those bodies with the legal mandate to intercept communications for assistance, namely SAPS and the National Intelligence Agency. Letters were written to both to request whether they were able to shed light on the source of the recordings and whether they would be prepared to allow the NPA access to such recordings to verify the contents. The SAPS did not respond to our request, even though we knew that that intercepted McCarthy's mobile number. A further issue that concerned MSHA was the fact that Nuka and McCarthy had not been given an opportunity to comment on the allegations against them. Then there's a meeting on the 30th of March, and at 257 the prosecution team consulted with Nuka on 2 occasions, 20 and 24 March, to get his comment. and over the page, at 259, I suggested to Chair that we should give McCarthy a list of questions, like we did with NUCA. I also suggested that we give McCarthy the option of listening to the recordings.
Isn't it
Sorry, my lady, can I just take you through it, because it's apropos what you put to me about the timing. 261, both Chair and I could not understand why McCarthy was being so evasive. 262, Mziati and I reported on our interactions with the NIA. The NIA had informed us they were in the possession of intercept recordings of conversations obtained during the course of an investigation into the leaking of the Browse Mole report. We were shown a copy of a certificate signed by a judge authorizing the interception of the recordings. Mziati and I listened to the NIA recordings between 26 and 28 March. The NIA played us recordings of conversations between McCarthy and others. The NIA were in possession of most, if not all, the recordings. And then further down, they say what's in the recordings, but at 264, Chair was undecided about what to do. He had not listened to the recordings himself. So when one looks at D7 and they're framing a letter about following representation and information given, at this stage, Chair is undecided what to do. He had not listened to the recordings himself. He was reluctant to do so. Initially, he was concerned about the implications of using NI information to make the decision. Matsuka and Ramaiti shared his concern. We knew that if Chair relied on the recordings, they would have to be made public. Once the NI confirmed they were willing to allow the NPA to make the transcript according to the possession and that they'd allow us to make them public, the obstacle was removed. And then on the evening of 31 March, Chair listened to the recordings. So it may not be that they're compiling, they've got representations, they're preparing a draft, but clearly at this late stage, he had not yet decided what to do.
Well, what also bothers me, Mr. Epstein, if you look at paragraph 256, a further issue that concerned Mshe was the fact that Nguka and McCarthy had not been given an opportunity to comment on the allegations against them. Mshe felt that this was important to do before he made a final decision. What I want to put to you, what I find strange, is that the questions were sent to McCarthy on the 2nd of April, after the decision had been taken.
I'll have to check that, because I think that they sent it to McCarthy earlier and he responded saying he wants additional information. I'm
But
not
what
sure
I'm
if it was only sent on the 1st of April.
But what I'm trying to put to you, that Mshe was concerned about this, but he made the decision nevertheless, because that brings the question, why was the 1st of April such a magic date? Why did he have to take the decision before on the 1st of April?
And unless McCarthy had by that stage indicated that he was not going to cooperate.
McCarthy said he wanted to listen to the tapes.
He wanted to listen to the tapes.
Yes. So also, the other thing that is crucial, as my brother raised it yesterday, is that Mzinyati and the Hofmeier briefed the team about the contents of the recordings. Now, what is it that Mshe heard when he listened to the tape that he was not told by McCarthy and Mzinyati that made him to change his mind?
Well, we'd have to speculate about that. Perhaps seeing is believing and hearing is understanding, more in terms of context.
Okay.
But we agree that there's nowhere in his reasons or in the affidavit where he tells us if there was anything new that he found which was not told to him before. There is nothing like that.
In his statement, I don't think he gives the timeline as to when he found out the role of McCarthy, other than what was told to him. I mean, we have a bland statement by Hofmeier, is we reported to him. We listened to the tapes and we reported to him, told him what was in it.
But they had this meeting where everybody was present, where Mzinyati, where he says in paragraph 252, Mzinyati and I reported on the content of the recordings. and there was general agreement that their contents were shocking. If authentic, they cast serious doubt on the integrity of McCarthy.
So he reported on the contents, but we don't know the detail that he gave. Can I have a moment? So we go to paragraph 269, where where Shea had now listened to the recordings. And perhaps if I could ask you to go to the previous page of 266. Until the evening of 31 March, only Mzinyati and I had listened to the recordings. Mshe decided it's time for him and the deputies to listen to them. On the following day, on 1 April, Mshe met with the deputies and with Ngwengwe. It's evident from the record of that meeting that he was disturbed by what he heard on the tapes. Until the night before, when he listened to the recordings himself, he had relied on reports from Mzinyati and me to tell him what the recordings contained. He told us that listening to the recordings had made him angry. He informed us that he could not go on with the case and that he had decided to drop the charges, in other words, to discontinue the prosecution. Mshe felt betrayed by McCarthy. Once he heard the recordings, he realized the extent to which McCarthy had manipulated him and others in the NPA. He understood that McCarthy's insistence that the institution of the prosecution be delayed was not innocent. Rather, it was politically motivated. There's nothing wrong with somebody hearing something and then, or being told something, but then you listen to the recording yourself and it takes on a different complexion. It creates a different meaning, or you realize the extent, as he says, of what was going on behind the scenes. So can I turn to the reasons then, Mshe's reasons in the media statement, and just look at what it is that he said. And I want to, if I may, just highlight certain paragraphs. It's at JS 10, the finding affidavit, page 120. In the middle of the page, he starts off, of course, by saying at the very top, I stand before you today to announce the most difficult decision I've ever made in my life. That was the same ugly decision that the director had to make in the House of Lords decision I referred to. He says in the fourth paragraph, over the last 3 weeks, the NPA has been engaged in a difficult and painful process of dealing with allegations that the case of Mr. Zuma has been affected by manipulation and abuse of process. We have come across information about collusion between the former heads of the Directorate of Special Operations and NPA to manipulate the prosecutorial process before and after Polokwane elections. We regarded these allegations as extremely serious and set out to investigate them as fully as possible within the limited time at our disposal. I started off yesterday by quoting the DA's own affidavit, criticizing the conduct, stating that it was plainly most irregular and worthy of strong criticism. And they also say in their affidavit, the irregularity of McCarthy's conduct is not to be minimized. McCarthy was not some maverick on the outside of the NPA. For all intents and purposes, he was the NPA at the time. And when the public look at the integrity of the NPA and the independence of the NPA, it's McCarthy they look at. That is why he is the central focus of the entire process that was unfolding. And where Mshe says in the 5th paragraph that they regarded the allegations as serious, we know not only did he regard them as serious, but so did Mr. Self of the ideas I've referred to, Hofma, Mziniati, and it reduced Downer to tears. Then, if we can go over the page, he deals with, in the middle of the page, under possible abuse of process. In the course of the representations, the defense made certain very serious allegations about alleged manipulation of the NPA and indicated that these were substantiated by recordings of certain telephone conversations which it intended handing into court during the intended application for a permanent stay. And at page 130, he deals with the conclusion. The 2nd paragraph. He says, using one's sense of justice. So it's using his sense of justice. Using one's sense of justice and propriety as a yardstick by which McCarthy's abuse of the process is measured, an intolerable abuse has occurred which compels a discontinuation of the prosecution. And in the middle of the page, it follows, therefore, that any timing of the charging of an accused person which is not aimed at serving a legitimate purpose is improper, irregular, and an abuse of process. A prosecutor who uses a legal process against an accused person to accomplish a purpose for which it is not designed abuses the criminal justice system and subjects the accused person to that abuse of process. Can I take you, Lords and Lady, to Downer's affidavit, volume 33, at page 3177. At paragraph 60, the bottom of page 3177, Downer says, we can start at 59. I confirm, he says, that the prosecution team believed that the timing of the announcement was very significant and may have far-reaching consequences. Now, this is the very person who is insistent on proceeding with the prosecution, but this is his view. 60. I confirm that our disquiet was premised on the delay being seen to be protecting President Zuma for no good prosecutorial reasons. 61. I confirm that the prosecution team did not regard the timing as something incidental to the prosecution. I confirm that the prosecution team recognized that any decision to delay the prosecution for reasons unconnected to the prosecution was improper. I confirm that the prosecution team felt so strongly about this that we had initially decided to resign from the prosecution in protest, but had reconsidered this in the interest of the NPA. I can't put it any more strongly than that of Downer himself realizing the impropriety of what had been going on in delaying the prosecution. And so Mshe continues at page 130 of his statement. In the middle of the page where the paragraph starts, abuse of process through conduct which perverts the judicial or legal process in order to accomplish an improper purpose offends against one's sense of justice. McCarthy used the legal process, he says, for a purpose outside and extraneous to the prosecution itself. Even if the prosecution itself as conducted by the prosecution team is not tainted, the fact that McCarthy, who was head of the DSO and was in charge of the matter at all times and managed it almost on a daily basis, manipulated the legal process for purposes outside and extraneous to the prosecution itself. It is not so much the prosecution itself that is tainted, but the legal process itself. And then finally, in the last page, he says in the second paragraph, in the light of the above, I've come to the difficult conclusion that it is neither possible nor desirable for the NPA to continue with the prosecution of Mr. Zuma. And importantly is the following. He says in the fourth paragraph, let me also state for the record that the prosecution team itself had recommended that the prosecution should continue even if the allegations are true, and that it should be left to a court of law to decide whether to stop the prosecution. However, I believe that the NPA has a special duty as one of the guardians of the Constitution and the Bill of Rights to ensure that its conduct is at all times beyond reproach. And then he says, as an officer of the court, I feel personally wronged and betrayed, that on a number of occasions I have given evidence under oath that there has not been any meddling or manipulation of the process in this matter. It is with great regret that I have to say today that in relation to this case, I cannot see my way clear to go to court in future and give the nation this assurance. So having been manipulated by McCarthy, he's assuring the entire public in South Africa that this prosecution is untainted. Everything is being done above board. And in truth and in fact, that wasn't what was happening. So, in conclusion, I want to emphasize what I said right at the beginning. At the end of the day, we know that this is the discretion which the Constitution and the legislation reposes in the National Director. It's his discretion. And courts will not interfere unless there are exceptional circumstances within which to do so. And the question to be asked is this. If one sees that the integrity of the National Prosecuting Authority has been impugned, if in the eyes of the public, it can no longer hold up the badge which the Constitution requires, that we are independent, we conduct ourselves without fear, favor, or prejudice, without any outside influences, whether economic, whether political. Unless the public repose that trust in the National Prosecuting Institution, then the democracy in our country fails. There is nothing more important. You can't have a constitutional democracy unless you have an independent prosecutorial authority. And one has to ask the question, as he did, as Mshe did, is it more important to pursue the conviction of one person? You must put out of your minds the respect that this was the president. Is it more important to pursue the conviction of one person, even where the merits may appear to be good? Or is it rather more important to assure the public that at any cost the prosecutorial authority will not be impeded, it will not be affected, it will not be influenced by outsiders, and it will always remain independent? It's like the judiciary. There may be cases where your lordships will have heard and will hear where there is strong evidence against an accused, but it's inadmissible, it's hearsay. And even though you know it's true, you have to disabuse your mind of it, you have to ignore it, and that person has to walk free. Why? Because those are the rules we abide by. Those are the rules, and mostly the rules will provide what we need, will provide justice in the end. But we cannot allow the pursuit of one individual to trump the independence that we require of the NPA. And I want to end off by referring to the case of State versus Mohammed. We've only photocopied the head note and the relevant page that I want to refer to. It's a very long decision of the Constitutional Court. this really makes the point that the pursuit of the prosecution of one individual must yield to the greater public interest in assuring South Africa that its NPA is independent. We know that there's a lot of public sentiment about this case. It's been going on for years. Everybody knows about it. And one, with respect, and I don't want to give the bench with respect to jury speech, but one can't allow that kind of sentiment to trump what is most important, and that is to ensure the integrity of the National Prosecuting Authority. And in the matter of State versus Mohammed, the court said, and if I can refer you to the last page which we have attached, at paragraph 68, South Africa is a young democracy still finding its way to full compliance with the values and ideals enshrined in the Constitution. It is therefore important that the state lead by example. This principle cannot be put better than in the celebrated words of Justice Brandeis in Olmsted et al. Versus United States. And then he quotes, "In a government of laws, the existence of the government will be imperiled if it fails to observe the law scrupulously. Government is the potent and omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy." And I emphasize that the NPA at that time was McCarthy. I just want to deal with one final point, and that is the question of relief in this case. If I can ask the court to refer to the founding affidavit and the notice of motion.
You'll be done with your point in about 3 minutes, or maybe we can give you an opportunity to deal with it after tea.
It won't be long, but I may take more than 3 minutes. So can I just deal with it after tea? Otherwise I'm finished. Thank you.
We'll resume at 11:30. Court adjourned.
Like the judges are sitting there looking at us like, we don't know. We don't
I Also, I'm still there. Also.
Deputy National Director, which Mr. McCarthy was. He was a Deputy National Director, and he's appointed by the President, and Section 12(5) says, there's the NPA Act, the National Director or a Deputy National Director shall not be suspended or removed from office except in accordance with the provisions of subsection 6, 7 and 8, and 6, 7 and 8 are where the President may provisionally suspend the National Director or a Deputy National Director from his or her office pending such inquiry into his or her fitness to hold such office as the President deems fit, and subject to the provisions of this subsection may thereupon remove him from or her from office for misconduct, ill health, incapacity to carry on an account that he or she is no longer fit and proper to hold the office. On the question of relief, in the founding affidavit, the relief sought is in paragraph 2, page 1 of B1, reviewing, correcting and setting aside the decision. It says of the first applicant, that's obviously a mistake, means of the first respondent, taken on or about 6 April to discontinue the criminal prosecution of the third respondent in accordance with charges contained in an indictment of 27 December 07. And 3, declaring that the decision of the first respondent referred to above to be inconsistent with the Constitution. On the 6th, we know that the announcement was made about the withdrawal of the, that the prosecution is going to be discontinued. On the 8th, 2 days later, President Zuma appeared in the Durban High Court where the charges were withdrawn. So all they're asking you to do is to declare the announcement unconstitutional because the charges have been withdrawn. They're not asking for the charges to be reinstated. And in the case of freedom under law, if I can give you the references, 2014 volume 1, page 254. In the North Gauteng High Court, this was the judgment of Murphy J. And in that case, the relief they applied for in a review was setting aside of the decision of the first 3 respondents relating to the withdrawal of criminal and disciplinary charges against the 5th respondent, that was in Mluli. Full also sought an order directing that the charges be immediately reinstated and prosecuted to finalization. And Judge Murphy gave them that relief and directed that those charges be prosecuted to finalization. But on appeal of the Supreme Court, that reference is 2014, volume 4, 298 SCA. And at paragraph 51, Brunt J.A. said this: what remains are issues concerning the appropriate remedy. As we know, the court, I quote, did not limit itself to the setting aside of the impugned decisions. In addition, it ordered the NDPP to reinstate all the charges against Mluli and to ensure that the prosecution of these charges is enrolled and pursued without delay. And B, directed the Commissioner of Police to reinstate the disciplinary proceedings and to take all steps necessary for the prosecution and finalization of these proceedings. Then Branch continues, both the NDPP and the Commissioner contended that these mandatory interdicts were inappropriate transgressions of the separation of powers doctrine. I agree with these contentions. That doctrine precludes the courts from impermissibly assuming the functions that fall within the domain of the executive. In terms of the Constitution, the NDPP is the authority mandated to prosecute crime, while the Commissioner is the authority mandated to manage and control the SAPS. As I see it, the court will only be allowed to interfere with this constitutional scheme on rare occasions and for compelling reasons. Suffice it to say that in my view this is not one of those rare occasions, and I can find no compelling reasons why the executive authority should not be given the opportunity to perform their constitutional mandates in a proper way. The setting aside of the withdrawal of the criminal charges and the disciplinary proceedings has the effect that the charge and the proceedings are automatically reinstated, and it is for the executive authorities to deal with them. The court below went too far. So in that case, they asked for the withdrawal to be set aside. In this case, they're not asking for that. They're asking for the decision to be set aside.
Well,
So if,
then we needn't deal with the withdrawal and then the reinstatement.
so if you give them the relief, my lady, then all that happens is it will have to go back to the to the NPA to reconsider. The charges won't automatically be reinstated. That's the only point I'm
To
making.
reconsider what?
To reconsider whether to proceed or not proceed.
Has that decision not been
In other words, you will have found, my Lord, I'm sorry to interrupt, you will have found, if I'm unsuccessful, that the decision was irrational, and then that decision will be set aside, and then the decision have to be reconsidered by the present NDPP. But the charges won't automatically be reinstated. It's not what they've asked for.
The prayer in the notice of motion says review, correct. And this court will decide as to how is it going to correct this whole issue if it grants an order in favor of the applicant. But now you submit that there's no prayer that the withdrawal should be set aside.
Yeah.
Am I with you?
That is so. There's not,
But the withdrawal of the charges was as a result of the decision of Mr. Msha.
yes.
Now, if that decision is set aside, would the withdrawal still be valid?
Yes, it will be. The withdrawal is still valid. It's only the decision that's set aside. They haven't asked you to set aside the withdrawal. It must go back for reconsideration by the new NDPP. And I would, with respect, alert the court to
Now,
what
I
this...
think maybe it will be the decision of the NDPP to make, because if the decision is set aside, the NDPP would decide whether the withdrawal is not an acquittal. We all know that.
Yeah.
Yeah, but if we set aside the decision, then
It'd have to be
the
retaken.
NDPP will decide what we will do.
With respect, that is so, my lord. Thank you.
Thank you. Mr. Kemp, are you ready?
Thank you. My lords and ladies, may I commence to refer you and to quote you just parts of 2 paragraphs of a case of State versus Lamini. It's a 1999 4 SA 623 Constitutional Court judgment. In the judgment at page 93, Justice Kriegler says, choices often have to be faced by people living in open and democratic societies. Indeed, the right to make one's own choice is an indispensable quality of freedom, and often such choices are hard. Litigation in general, and defending a criminal charge in particular, can present a minefield of hard choices. Then he explains this by way of example. I would want you to consider that Mr. Maché in this matter had a hard decision to make, and I also wish, because it seems to me that there has been some tendency on the part of the applicant to label the timing of charges as essentially an irrelevancy. I would wish to draw your attention to the decision, and we've referred to it in our heads as well, to the decision of Saunderson versus Attorney General, Eastern Cape. It's a 1998 2 SA 38 Constitutional Court decision, and in that decision the Constitutional Court deals with the fact that since the Constitution, there has been a significant break from the common law past. Kentridge AJ suggests that criminal trials should be conducted in accordance with open-ended notions of basic fairness and justice. I will suggest in a moment why the fair trial protection of the accused extends to known trial-related prejudice. But my point here is simply that a narrow textual approach to Section 25D is likely to miss important features of the provision. The point that we would like, and we would make it in more particularity with the case law on the point, is there has been a tendency to equate the decision in this case to a permanent stay. I am well aware that the third respondent has been accused of that by the applicant. For reasons that will become apparent later, that is not what we have done, and that is not what we're asking you to do. But we do want to make the point right at the outset that a stay of prosecution or a decision not to continue prosecution does not necessarily have to have anything to do with the so-called merits in the sense of substantive facts making up the offence of the case. That is what the Constitutional Court says here. They say it extends to known trial-related prejudice for rights to a fair trial. And that must be so for a variety of reasons. But we say, if you are looking for basic authority with the contention that a permanent stay or the exercise of a discretion can only be where there is an impacting on trial-related rights of the accused, that is simply wrong as a starting point in our jurisprudence. In this case as well, the court refers to inter alia the effect of charging a person and him becoming the accused, and the negative effects and penalties and prejudice that results simply by virtue of being an accused. These forms of prejudice are unavoidable and unintended byproducts of a system, the court says. It should really only be visited on the convicted. And the court reminds us of the past, and it talks about vague statutory crimes which gave the state sweeping scope to investigate, charge, and prosecute opponents of a governing party. And one may well add in this instance, opponents of certain factions in the government and governing party. We say, my lords and lady, that it is simply even wrong to suggest that any timing of the bringing of charges is a trifling matter. It is not. It is in itself not. But in this case, we will deal with why it is in particular not a trifling matter in this case. If I may then start off by putting a certain proposition about applications, which I am certain you are well aware of, and what I wish to draw to your attention really is what has come up in argument. The DA, the applicant, contends that no, they have a different interpretation of what the recordings may mean or do not mean. It is not an exercise of interpretation. My learned friend, Mr. Epstein, has referred to it, but it's not a matter of assumption either. It's a matter of inference. And it's only if the national director had drawn irrational and unreasonable inferences that you can say that the factual matrix in which he made the decision flaws his decision. It is not with respect for the court in a situation like this to say, but we think the tapes mean that, unless you find that what the national director understood them to mean is wholly irrational and cannot be a reasonable interpretation thereof. And in that regard, if I can just make the submission to you, the fact that the persons in the National Prosecution Authority were better equipped than the court to draw the inferences from the recordings is also a factor that I respectfully ask you to consider. That knowledge that they had of the persons involved, how they speak, etc., is part of the inferential material that was available to them. Now, in these papers, the National Prosecution Authority has spelled out its version. That version accords with the record. The third respondent confirms it in several respects, and the documents bear it out. This application must be determined on the respondent's version. If the applicant did not want that, it had to ask for oral evidence or to cross-examine somebody, etc. But apart from that, and my lords and ladies, I know for hard way, because I learned it in NDPP versus Zuma, that is exactly how an application is approached, and we were on the receiving end of that. And in this case, you have a respondent's version. That is the version on which I am going to address you, and I make the submission to you that you're not free to choose the DA's version, even if you think it's more probable. That is not how disputes, insofar as there are disputes, are resolved in application proceedings. The NPA's version is not incredible, it's not irrational, and the NPA did not have to disprove the account of the applicant. The applicant had to disprove on paper the NPA's version. So as far as that is concerned, I am going to address you on the version put forward by the NPA. May I then make the first point of significance about this application and what it seeks. This application was misconceived. It started out as a Baja review. Hence, you will see paragraph 2 of the order declaring the decision unconstitutional was premised on section 33 of the Constitution and sections 8 and 9 of Baja. That challenge is clearly wrong. The DA subsequently realized that their administrative law challenge was flawed. It was fundamentally flawed. And may I, my learned friend has drawn your attention to the decision, and we've also referred to it. In the case my learned friend referred to, freedom under law. If you, he's given you the citation, it is 2014-1. I'm sorry, I'm looking at the SCA. Sorry, it is 2014 for SA 298 SCA. If the court looks, when you look at have a look at the decision at paragraph 19, you will see that the SCA says, with reference to this very application, which was before it in the matter between the DA and the NDPP, the 2012-3 decision of the SCA. And in that decision, Judge Nafsa said, listen, I don't know why you are trying to distinguish between a decision not to prosecute or a decision not to continue with a prosecution and a decision to prosecute. They're all the same. But he said it's not necessary to decide that because everybody agreed that, look, at least for legality review, there was standing. In the freedom under law judgment, the court says the following. Although the answer to that, the allied issues whether these decisions are reviewable under the provisions of PAJA. Although the answer to that question is by no means decisive of the matter, I nonetheless believe the time has come for this court to put the issue at rest. And the court then deals with the issue and it decides it that there is no PAJA review against the decision of the NDPP, whether it's a decision to discontinue prosecution, whether it's a decision not to start prosecution, whether it's a decision to prosecute, it does not matter. None of them fall under PAJA. They do not fall under PAJA. There is a limited review parameter, and that is legality, and in a case like the present, it can eventually only be irrationality. It can't be anything else. You will see that he refers, in discussing the matter, he refers to the judgment of Mr. Justice Nafsa, etc. And then he says, as I see it, that's in paragraph 26, the underlying considerations of policy can be no different with regard to decisions not to prosecute or to discontinue a prosecution. The view is supported by English authorities dealing with non-prosecution, and the court cites them. And he then says, my conclusion is that policy considerations are underlying our exclusion of a decision to prosecute from a PAJA review are substantially the same as those that influenced the English courts to limit the grounds on which they would review decisions of this kind. And he says the English courts were persuaded by the very same policy considerations to impose identical limitations on the review of decisions not to prosecute or not to proceed with a prosecution. In the present context, I can find no reason of policy, principle, or logic to distinguish between decisions of these two kinds. Against this background, I agree with the obiter dictum by NAFSA in DA versus acting in PP, that decisions to prosecute and not to prosecute are of the same genus. And although on a pure textual interpretation, the exclusion in section 1FF of PAJA is limited to the former, it must be understood to incorporate the latter as well. So that makes an end to the PAJA review, and in support of that review, the DA had suggested very clearly that Moshe was either motivated by personal ambition and the prospect of a permanent appointment as NDPP by Zuma, as no reward for the 2009 decision, or he buckled under political pressure. And it is quite interesting, my lords and ladies, to have a look at what the Supreme Court of Appeal, indeed in the 2012 free matter, had considered the issue to be. The court in that matter had considered the issue to be precisely what I've just read to you. Well, did he buckle to political pressure and therefore his decision was unlawful? Or was it otherwise a dishonest decision? And that was what this review was about. Now you know that that is no longer what this review is about. You know that the DA has accepted the bona fides and the honesty of Mr. Moshe in deciding on the issues before you. It follows, my lady and lords, that there is nothing left of that review. What you have before you is now a resort that, look, as a last desperate position, we say that this is irrational because, why? What did the applicant pitch its case at? It says the NDPP did not sufficiently, or as I put it, not at all consider the strength of the case against the NDPP. That is the case that it now makes out. My lords and ladies, I do not need to dwell on that. That is simply not correct on the papers. You see Mr. Moshe in his public announcement. Mr. Moshe says, I was unpersuaded not to proceed with this prosecution by anything on the merits that the accused made to me. I considered the merits were good on the substantive side of proving facts, at least on some of the charges, one would assume. So, how can anyone say that he did not have that aspect of the case in mind? May I then draw, and if I may just perhaps whilst I'm dealing with that, in the case that I have referred you to, the 2012 3 SA 486 SCA DA matter, in paragraph 45, the SCA said, the question whether in making the decision to discontinue the prosecution of Mr. Zuma, the NPA had acted in accordance with the law or had wrongfully and unlawfully succumbed to political power and influence as alleged by the DA is a matter for decision in the review application. After all, the papers have been filed. The fact of the matter is that that is no longer the issue before you. The only issue before you is what I have just now put to you. And, my lords and lady, I wish to refer you to some of the documents that have evoked considerable interest of the court. If I can say to you, it seems from the record that the first response of the prosecution team, detailed one, was made on the 18th of March. There were previous responses, and then my lords and ladies will also see that there was a detailed proposal by the team as to how to react. My lord and lady will find that at C28 and also at D7 of the record. And may I say, and I'll see whether I can find it for the court, it seems to me that the contents of the representations were conveyed to the team approximately the beginning of March. But the contents of the tapes, as established by Mr. Hofmeyer and his colleague, was given to them on the 18th of March. And they referred to being advised of that, and they then provide a memorandum, and they provide a letter, and you will see the letter at D7, and it seems that that letter was received on the 30th of March by the NDPP. And if one looks at the records and the chronology put up by the applicant and by the first and second respondent, we know that there was a meeting on the 30th of March between the team and the NDPP and the top management as well. So, my lords and ladies, this letter says very clearly, and it's a draft that they put up and they want Mr. Maché to send. They say, well, we think that you should do this. And in that, they do say that the merits are strong. They deal with that, and they want the NDPP to tell the third respondent's attorney that. They deal with the fair trial issues. They say, well, that this section of our response is just limited to trial delay and adverse publicity. And then you will see at D14, they go on to deal with the oral representations, etc. And they say, from the oral representations which you have made, and the reports by Mr. Hofmeyer and Advocate Msinyati on the material to which you granted them access, I understand your client's main allegations to be the following. And then you will see it says that conspired to support the former president, McCarthy manipulated the timing, and then Mr. McCarthy abused his position by instructing or allowing certain erstwhile employees of the DSO to gather intelligence regarding your client, which culminated in the production of a so-called Browse-Mole report. Mr. McCarthy had improper communications with a member of the media and someone believed to be a foreign intelligence operative regarding the prosecution of your client. That probably refers to the leaking of a 8-page memorandum, etc., etc. But be that as it may, the prosecution team, and I do not really want to call them that because there's a sort of automatic assumption that the prosecution team excluded people like Mr. McCarthy. That was not what is reflected in the various litigations, nor were Mr. Downer and Mr. Steinberg and Mr. Baloy carrying the can on their own. You can look at the reported cases, you can see I had counsel, other members of a team in what were criminal cases. So those people were part of a prosecution team for those purposes. The proceedings before Judge Msimang was part of a criminal proceeding. It wasn't some other application. The Section 179(5) application was a separate civil application, but not that. So what I am submitting to you is that the members of the team feel confident enough about what they know and what Mr. Maché know and what the oral representations were, and they've seen the written ones. One can see it because Mr. Downer refers to excursus B, and as we've drawn attention to, he could only have known that there was an excursus B if he had read the written submissions. You will see that he says these allegations have come as a complete shock to me. That would now be Mr. Maché and the other members of the top management of the NPA. Without the material to which I would hardly have been able to give any credence to these claims. You will see that what he is saying is, I'm beginning to understand now what you're saying about the Browse-Mole report. If it weren't for this, I would never have believed what you were saying to me about it. I must say, I would certainly think that Mr. Maché had before February 2009, he knew about the Browse-Mole report. How much he knew about it, one does not know. I can also say to you that it is pretty clear from the affidavit filed by the third respondent is that the whole Browse Mole thing became really a public knowledge item as to more or less what happened there. When Mr. Bakoli was engaged in his battle before the Gingwala Commission and in the subsequent civil litigation, it is in there that this became more or less public knowledge, and detailed knowledge about that emerged, because Mr. Bakoli was being blamed for the Browse Mole debacle. And he was, of course, defending himself and saying what actually happened. But what I'm drawing your attention to is there is no doubt that Mr. Maché has before him, and he says, I read and I considered and I valued the input from various members of the NPA, including the team. They tell him that the merits are strong. How can anyone suggest that he did not have that in mind? You will see in the chronology of the meetings on the 18th of March and the 30th of March, Mr. Maché says, well, we don't have to discuss the merits further. We all know that they are good. We all agree on that. So how can anybody make the submission with success that Mr. Maché did not know about that, and he did not have that in mind when he made the decision? And if that is so, where does this review go? It goes exactly nowhere. There is nothing about that that says that now he knows about it, that he, on the 31st of March or the 1st of April, went and drew a line through the merits. On the contrary, on the 6th of April, he still sticks to saying, oh, the merits are pretty good. So that line of attack on the decision is, with great respect, stillborn. It is not even something that you should give any credence to. So, if that is the rationality attack, it has failed. It has failed at the outset. If you decide it has failed, it does not mean that you have said that the allegations made by the third respondent or his representations are true. It simply means that the applicant has not on the papers demonstrated the irrationality. It is not necessary for you to delve into these allegations and to find out whether they are true. Of course, the third respondent contends they are true, but it's not necessary for this decision. And you can deal with a matter very simply by saying, well, this is a rationality complaint. Mr. Maché had it in mind. He dealt with it. The team who were in the best position to advise him as to the merits did. They agreed on what the merits were. It just seems, with respect, wholly irrational to say that that is the basis of a rationality challenge, that he did not. What the DA says is something else. What the applicant says is, we don't think that he put enough weight on that consideration. But that is a different exercise. That is not a rationality exercise. That is an exercise when you ask whether the decision is reasonable, etc., etc. It is not a rationality exercise. May I then say to you that one must look at the NPA's decision in the context of the answers given by Mr. Hofmeyer and confirmed by Mr. Maché. You will also see Mr. Downer confirms the essential interference on the part of McCarthy as gathered from the materials, and his view is also that this was a very serious matter. You will see what the team says about these things in the letter. It is clear that they say that this is serious. It is not something that can be wiped under the carpet. And may I put it to the court at this level? It is an enormous affront to the criminal justice system. It is an enormous affront to civil society and the people's structures of governance. The choice of a president is of great importance in how we govern this country. In this case, what you see is the NPA, with its enormous powers to indict people and to prosecute them, and to use their powers in the criminal justice system as to when they do that. These powers are now blatantly used to try and decisively influence the outcome of the presidential election process. We say to you, that is an enormously serious thing. It is not whether there is a delay of 7 days in the issuing of the charges. That is not what this is about. This is about why were the powers used in that way. And it was used in that way to try and inflict a very significant event upon the people of this country. There is no other way of looking at it. If you just take, for example, if someone who had to decide on when to arrest the president at that stage, and they knew that there were riotous conditions likely in a certain jail, and they arrest him so that it coincides with the information that there's going to be a riot in that prison, and let's put him there and let's hope for the best. If that gets found out, whether he is killed in the riot or not, it will be an enormous misstep. It will be an enormous abuse of the NPA's powers. The fact that it didn't work out in this case, like the persons involved in this planned, matters not. It does not matter. It cannot be that if I stood before you today, and as a result of this strategy, Mr. Zuma, who would then not be the president, lost at Polokwane as a result of this strategy, that you would say to me, but it was insignificant. It was just a matter of timing. And what does it really matter whether he gets the indictment a week early or a week late? That is not what this case is about. It is not what Mr. Mashi's decision is about. His decision is about the enormity of what you were trying to achieve by perhaps a very simple step, and a step that in itself isn't so significant maybe in the grand scheme of things in this prosecution. But it was enormously significant for some other reason. And, my lords and lady, if the DA is right that, because it didn't happen that way, it is nothing, then we deserve to be told that, so that the people will know that nothing really happens if somebody in the NPA does something like this. And may I come to the decision of Mr. Mashi? And yeah.
Before you go to the decision of Mr. Msha, on the basis of the communication between Mr. McCarthy and Mr. Nguka, they are assuming that everything is correct and was obtained legally. Was their aim not to that the service of the charge sheet should have an impact as far as the election is concerned?
Well,
And that had nothing to do with the charges themselves.
well, may I put it to my lord this way? As I understand it, the whole idea about delaying the service of the charge sheet was this would improve the prospects of Mr. Zuma not being elected at Polokwane. You may say to me it's counterintuitive, you may say a lot of things about it, but if you ask for the reason why it was delayed, that is the reason. And the fact that it didn't work doesn't change that what we have here is an NPA that will allow its powers and will exercise its powers to secure certain political results. That is what this case is about. It is not. My lords and ladies, may I say to you, if the trial goes ahead, forget all the other skirmishes about permanent stays and things like that. The fact that the indictment was served, say, on the 28th of December rather than the 1st of December or the 31st of January matters very little to that trial and its outcome. That is not what this case is about. I accept that. And it has never been suggested otherwise as far as that is concerned.
So I would then say that the position held by Mr. Downer, you'll recall that Mr. Downer and his team have consistently argued that the question of service of the indictment must not take into account extraneous matters.
Yes.
Be they political, whatever. Whether they are serving on the president or whoever on the eve of elections.
Yes.
If they decide to serve, they need to serve.
That was his stance.
Consequences would fall.
Yeah.
Now, would you characterize that as the correct position?
My lord, yes, in principle that is the correct position. I am not saying that if there are valid reasons you can't serve it later or earlier other than simply the merits. But what I am saying to this court and what we are contending for, that in this case the reason for that was very different. The reason was to have a different individual as president of the ANC. That was what this was all about. And that is an enormous thing. It is like we are arresting somebody that we know is going to be a kidney donor to Mr. Zuma. We know he's critical. If we arrest this person now instead of in a week's time, maybe it will be too late. If it happens that another kidney is found after you've done it, it does not change the enormity of the abuse. The abuse is not, well, you get it a week earlier or you get it a week later. It is, what is the NPA's powers being used for? It's being used to determine who is going to be the president of this country. That is exactly what Mr. Justice Harams had in mind when he says, well, if it's being used for an ulterior purpose, that is quite different. And you will see that is how Mr. Maché saw it, that's how Mr. Hofmeyer saw it. And other members of the team and of the top management also saw the significance of it. It is not that Mr. Downer and Mr. Steinberg did not realize afterwards what had happened. They were differing about, well, what do we do about it? Do we go to court and say, oh, this is terrible and we're sorry, we have to make all these concessions? Or do we discontinue the prosecution? They were never saying that this was not gravely serious. My lords and ladies, I ask you, Mr. Downer is a trial lawyer, he's a hardened trial lawyer. He didn't cry when Justice Msimang kicked out their case. He didn't cry tears of joy when they won battles against us. What does he say to you? He says, I cried not when I heard Mr. Maché's decision, when I heard what Mr. McCarthy had done. Mr. Steinberg refers to this as Mr. McCarthy's Machiavellian reasons. Both of them understand what is going on. Mr. Hofmeyer understands, Mr. Maché understands what is going on and what this is all about. This is about using the NPA's powers to have a certain political structure in this country. How can that ever be lawful? How can that ever not be gross and grave? And if one looks at Mr. Maché's announcement, he is talking about that. He's not talking about the fact that the indictment was served a week later. He says, I'm standing up before you and I'm telling you about this and I make this decision so that these things never happen again in the NPA. He's not talking about an indictment being served a week early or a week late. If you read that announcement like that, it is because you do not want to read it in a sensible sense, and meaning that it actually does convey. What is Mr. Maché saying? He is saying, well, in this case, there were outside people, and no one has ever tried to explain why Mr. McCarthy was discussing all this with Mr. Nuka, which we know from the context of this litigation is a fairly sworn enemy of the president. Why is he discussing these things with him? Why is he discussing the case with him? Why is he giving him an 8-page summary of all the good points in the Section 1795 litigation that is pending and in the warrants? He gave him the 8-page summary in connection to the warrants appeal. Why? And if you look at it, what Mr. Maché is doing and saying, is actually something very laudable. And it's a clear message to the government and to the president and to every other president. What Mr. Machar is saying is, look, if you use, and if officials, the high heads of our National Prosecuting Authority, use their powers to engineer political results, we will tell you what we will do. You want us to prosecute this person on your terms. We will tell you what we will do. We won't prosecute him. Now put that in your pipe and smoke it and see whether you're going to try that again. If you read what he is saying, that is the sense and sensibility what he is portraying. How is that not something that should not be upheld and not be lauded? And there is no effort to grapple with that aspect. There is no effort on the applicant's part to understand that Mr. Machar is giving a message in that conference also to the government and to political parties and to members of the NPA. He says, keep away from this. If not, this is what will happen. You may say it's an overreaction. You may say he should have chosen a different case to make that stand. But it happened in this case. And that is why he did it. You may not like it. I may not like it. I may also feel that if somebody has committed a crime, he should normally be prosecuted. But you cannot say that that reaction and the reason for it is irrational. It is indeed, as I have put to you, laudable. And if you look at what he is saying, he is, as my learned friend indicated to you, he is saying that in his statement, as an officer of the court, I feel personally wronged and betrayed that on a number of occasions I have given evidence under oath that there has not been any meddling of or manipulation of a process in this matter. And that is correct. He gave such affidavits also in the proceedings before Judge Msimang. And may I make it very clear to the court what was an issue in that case. There were two things in issue. The prosecution wanted an adjournment. That was resisted. And it was not just idle resistance. There had been 6 months set aside for this trial. And there were a great deal of unhappiness about this. There was also, in response, a permanent stay application brought. It is in that application that the allegations were made that Mr. Nka and Mr. McCarthy in 2003 decided, no, it suits us to push Mr. Zuma to the side and then to prosecute Mr. Sheikh, and the harm to the then Deputy President would be far greater. And if we're successful in the prosecution, great, then we've got a platform to have a go at him if we cannot make him go away. Otherwise, by then, those allegations were made. There were also a number of other allegations, including that the 2005 decision was a hasty decision. Judge Msimang dealt with the application for the adjournment first. That was refused. The state stood there. They said, we're not withdrawing, we're not going on, we're not doing anything. It was then struck from the roll, and there was nothing to bring a permanent stay against, because as we know, both the eNCA and the Constitutional Court thereafter reaffirmed that there was nothing left of those proceedings. So, where the sting lies of the brass mold in the current proceedings, it lies at a level, and you will see that there are allegations made in our papers and in the NDPP's papers in some detail about the brass mold and what happened and what happened. The real sting in the allegations was Mr. McCarthy, in August of 2006, deposed to an affidavit which we have quoted both in our heads and in the papers, in which he said that the NPA had observed the higher standards of ethics, lawfulness, propriety in investigating the matter against Mr. Zuma and in prosecuting him. And may I ask you to note the date? This was August 2006. At that stage, as we later know and as we've set out, at that stage, Mr. McCarthy is still busy with a brass mold investigation. He knows by now, and may I say to my lords and my lady, you will find no mention of it in those papers because nobody knew about the brass mold thing. And I have asked to check. You will even, before Mr. Justice Nicholson, I don't think there was any reference to the brass mold issue. It is something that became acutely known later. What you will find is at that stage when he makes that affidavit, and this is now an affidavit to persuade the court to reject the permanent stay application. So it's an important document. He makes those allegations. He is busy continuing with the brass mold. We learn 2 years, year and a half later, that actually Mr. Pakoli had told him, look, this is illegal, you must stop it. He did not stop it. What we complain about and what our complaint was, how can you, as a national prosecuting authority, say that to a court when you know what you are busy with? And may I make it very clear, I do not blame anybody from the prosecuting representatives who were in that court litigation. They did not know about it. I accept that. But Mr. McCarthy knew about it. He was the one doing it. And he was the one who made that main affidavit. And it was him that Mr. Mashir was supporting. And when he complains and says, I feel wronged and betrayed because I gave evidence on oath that there was nothing wrong with this, I can't ever do that again. And if you look at Mr. Hofmeyer's affidavit, you will see that he says, well, you know, we have always said that the allegations of political meddling, interference, and political manipulation of this prosecution is the biggest load of hogwash that we've ever heard in our lives. And he says, well, when I saw this, and I saw these tapes, and I heard what they're still saying about these things, and I heard what they're saying about the Procedural, and you will see Mr. Downer and the team saying, well, we sort of now understand where Procedural fits into the thing after the representations, which seems to me to be quite correct, because Mr. Downer and Mr. Steinberg knew about the Procedural, I think, from probably the end of 2007. But they didn't know any detail, and as far as we know, they were never involved in any of those things. And my lords and lady, you would also have seen we've never made any allegations against them and been involved in what we're talking about in this matter. So, what you have, and we say, the courts in England, and you would have seen that in the judgment of the appeal court that we have referred to, Freedom Under Law, you will see that the South African Supreme Court of Appeal has regard to the English decisions on this. And whatever may be the position as far as abuse by the executive is concerned, and I'll deal with that, and I will refer you to the latest cases, or the most authoritative latest cases on that issue of permanent stays, etc. But if I may say to you, there is a difference between an abuse of power and prosecutorial misleading of the court. An abuse of power by the executive is dealt with in a certain way. As far as the prosecution is concerned, I have quoted to you the decision in Early. I will give the court a copy of that decision as well. Early and those lines of cases have never been retracted or detracted from in the jurisprudence. They all proceed on the basis that you tell an untruth to a court about a material issue view of a prosecution and see what happens. In Early, the court said, judges can only make decisions and counsel can only act and advise on the basis of information with which they are provided. The integrity of our system of criminal trial depends on judges being able to rely on what they are told by counsel and on counsel being able to rely on what they are told by each other. This is particularly crucial in disclosure and public interest hearings, public immunity hearings. And they say, furthermore, in our judgment, if in the course of a public interest immunity hearing or an abuse argument, and I leave out one or two words which are not important, prosecution witnesses lie in evidence to the judge, it is to be expected that if the judge knows of this, or this court subsequently learns of it, an extremely serious view will be taken. It is likely that the prosecution case will be regarded as tainted beyond redemption, however strong the evidence against the defendant may otherwise be. It is one of the cases why we say to you, it is simply not so. That strength of case makes up for everything else. In what we say in this case is, and in Early's case, the same thing happened. In that case, the accused pleaded guilty. They were found guilty and they were sentenced, and then they found out that the prosecution had actually not told the entire story to the court as to how they were arrested, how they were made to participate in this custom scam by certain entreaties, etc. And they did not know that at the time, and the defense counsel didn't know it, and even the prosecution counsel did not know it. And when the Court of Appeal learned of this abusive process, because it didn't affect their guilt, they pleaded guilty, they were guilty. The court said, but maybe they would have brought a permanent stay application in this case, and maybe they would have been successful. The fact of the matter is, we have been told a different story by the prosecution. This is not going to happen. They quashed the convictions and they refused there to be a retrial, despite the undoubted guilt of these people. It is one of the instances where courts, and we would very much consider that South African courts would be similar, would say, no. There was a permanent stay application. You told the court that everything that you'd done was of the highest order. There was nothing illegal, there was nothing unlawful, there was no impropriety about it. That was untrue. You knew what you were doing at the time. And you will see what our complaint about the brass mole is. But that is even at a different level. The complaint is, come on, how did you see what was going on in the then Mr. Zuma's, he was then the deputy president, in his attorney's bank account? How did you manage that, Mr. McCarthy? That would have been the first question if he took the stand. And just explain to us, how did you manage that? Because to the best of our knowledge, you didn't have anything remotely like a warrant at that stage. It is a fundamental principle that you do not mislead the court on such issues.
Yeah, Mr. Kim, I understand the submissions that you are making, but on the facts and circumstances of this case, can you just explain to me, as my colleague said, what was the magic about the 1st of April?
About the 1st?
The 1st of April 2009. Mr. Mche was told about the contents of the cassette, and he stated that a decision should be made by the 1st of April. And that decision was made on the 1st of April. Doesn't this affect or has an effect on the rationality of the decision that he took on that day? Why was he in a hurry that the decision should be on the 1st of April?
Well, my lord, as defense counsel, I would say to you, well, if representations were made to him not to continue with the charges, there was a certain timetable in the case. There had to be a permanent stay application that had to be prepared and so on.
And it had not yet been prepared.
Sorry?
The permanent stay application, the papers Have they been served on the...
No.
Not yet?
No.
Yes?
That is one of the reasons why I would submit to you the defense wanted an answer on their representations, because if they were rejected, then that application had to be completed and put before the court, and it would have been a massive thing. Although, I must put to my lord is, if you look at the representations, you will see one theme running through them, and that is we will not have this decided on paper. The Criminal Procedure Act says evidence is viva voce, so we all get into the witness box at that hearing. And you will see that the prosecution team says no, they will resist that, but so be it. But
when was the application for permanent stay to be served on the NPA in terms of that court order?
my lord is now asking me something that I can't remember off the top of my head. What I'm saying to you
I think it was sometime in August. Maybe can somebody assist?
I think it was to be heard in August, if I remember correctly, my lord, but I will check it out.
Okay, yes.
But what I'm saying to my lord is, I would think that the defense and from Mr. Zuma's side, there would probably be also an urgency about, look, I'm going to be inaugurated as a president in a couple of months. We have to know where I stand, if the case goes ahead or not. I would think that for a number of reasons, it
but
was fairly...
when representations were made, is there any document showing that Mr. Mpse was put on terms to respond by the 1st of April?
No, my lord, I can't recall that. And sorry, I'm saying to you something that's not on the papers.
I think maybe I'll give you more time just to check your papers, as it's almost one.
No, I don't think it's on the paper, certainly. I'm simply saying to you, because that's probably the worst answer that I can give you, but as far as I know, he wasn't put on terms during the representations. But may I say to you, they were urgent. But whether the date had to be the 1st of April, or the 10th of April, or the 15th of April, or the 30th of March, I don't think that was
but
really...
the date was specifically put to the team that it must be at the 1st. I think maybe this will be an appropriate time to adjourn, and we'll continue after.
That may well be so.
Court adjourns.
Shirley, haven't seen you today, my friend. What's happening, my friend?
tell you the
Now,
context.
the spreadsheet that we put up there
allegations from
is
the
basically the question of
2005
technology and assets that were procured
And
during
the
this particular
contention was
period.
ECA
Between
rejected was
the 22nd of July 2009 and the 30th of November 2009,
in October.
an amount to the tune of about 737,881 rands was spent during this particular period. And it was spent amongst other things, and I'm just going to mention some few of these items.
No, we're actually not reviewing
For an
these
example,
things, so
it was
there's no
spent on
need
your
for you to make
VS125 wireless video camera detector. It was
the
spent on the
argument was
DMC3 detector of
Hang on,
mobile
when
and
you-
wireless
even if it
activity.
was now, as I
It was
say
spent
now,
on
formality,
conducting a
when you
basic
were looking
course
at
in electronic
reinstituting the
eavesdropping.
charges, why didn't
It
you
was
give
spent
us
on your
even a
telephone and line
comment?
analyzer.
Just a hearing.
It was
And
spent on an item
those
referred to as the
allegations
5000 spectrum
of political meddling was
correlator,
put up to say,
amongst other things.
in the light of those
Now,
allegations, why
in
wouldn't you want
year
to
2010,
hear
there were
us?
two transactions
The ECA said no.
that
You
led
either have the right
to
to
an
be
expenditure
heard
of
or you
about
didn't have the right to be heard.
54,720.
Those things don't
And
come into
that was
And that
in
is why
relation
the
to an
judge
advanced
says,
course
"No,
in
this is not
electronic
about
detection
whether that was
and a
true
basic
or
course in
anything like
electronic
that."
eavesdropping.
It was not relevant
And between
to
the
point
10th
that
of
you were really
October
trying to make in the
2011
case.
and the
therefore they
14th
were
of
struck out.
December 2012,
So there was no decision.
an amount of 562,384 rands, 81 cents was spent amongst other items. A sweeper
As
spectrum,
far as the 2003
an
situation is
X-sweeper
concerned,
spectrum,
it must be borne
a
in
TG
mind that its
Vican
common cause
J56
was a
signal
public
jammer,
announcement as
a
to the prima
CPM
facie
700
case
deluxe
against the
counter-surveillance
president,
probe monitor,
and
an ETA 3A single
That
line
was
telephone
against
analyzer,
the advice of
amongst
the
others. I'm just mentioning
and
some few of the
public
items.
protector.
And
much
then on the
later we heard
31st
that the
of
public protector's
January
findings are
2013,
actually binding. And,
to the 1st of
findings
February
said that,
2013,
the
an amount of 260,298 rands, 49 cents, was spent largely on the Osco Spectrum Analyzer 8 gigahertz and a Mark II handheld
simply say,
receiver.
well, we did not see any.
In 2014, excuse me, we have one transaction recorded
If I may just briefly address
which
you
led
on
to an
the law.
expenditure of
And also, ladies,
40,346.88
I have undertaken to
cents.
my learned friends
And that
of
was
the
for the
applicant to
Fluke
provide
air
you with a
check
copy of
Wi-Fi
the case
tester.
that I referred you to,
Now, all in all,
Maxwell's
ladies and
case.
gentlemen,
That
the
is a
total expenditure
2009
between
reported
2009
decision in the
and
UK.
2014
In 2011,
incurred thus
there
far
was
with the
another
procurement of
decision that I will
the technology and
give
assets
you.
of this nature
It is
was to the tune of
decision of
1,684,131 rands, 18 cents.
versus the
Now-
Attorney General of Jersey.
Therefore, at
And,
the center of these
that
matters are at the
case
center of,
basically
first and
deals
foremost, the issue in dispute
It seems
being
to
the
me
fact
still
that
reflects the current law in the United
these are
Kingdom.
matters that fall
And it is
within the
it's an
capability and
interesting
competency
case with
of
an
the
interesting outcome.
of a state security or an intelligence capability
facts were
that
briefly
resides with
that
the
the
state
police
security
authorities
agencies and so on. And that's the issue that
Past
is at the
various
center of
countries through which
the issue of
drugs
the
smuggle
existence of the rogue
was
unit
going
and the work
to
that is
travel,
ongoing
whether they could fit
at that level.
tracking device to his vehicle, and also
Now-
an audio-visual device. Some
And
the
of course,
countries
as I had said,
no,
there is
can't
further
do
work
it.
also
The police
that's still
and they
going to
did
be
it. They
conducted
put,
around these issues. We're just for now
audio-visual,
just reflecting on what
recording
actually
device
is the
on it.
issue. So
And the person was
some of the issues that have
he was
been articulated at the public level
according
attributed to an
the
investigation of
reported
this
judgment,
nature as an investigation
would
of
be
either
interested to
an
see
individual or
that he had
individuals.
apparently earned 142
And
million
that can't be true.
British pounds out of his
What
past drug
Hawks are
smuggling
investigating is the
activities,
existence
which is a
of
mind-boggling
such a rogue
sum
unit, and of
when
course,
you multiply
the different sort of
it
role
with
players
25,
that were either
And
there
the trial
or not there
judge
during the said period,
on
for an
hearing a
example, as and when
stay
the rogue
based
unit
on this
was
abuse
established in
refused.
2009.
The Court
And
of
therefore, it is
Appeals
part
said,
of an
look,
ordinary exercise to send
whether
questions
you grant a permanent
to
stay or
people
not
that could have been
is a
there or
question of broad
may have
discretion.
been there
It
at the
is
time
not
when
so that there is a
some of these
specific
activities
but-for
were taking
category,
place.
Like,
And the fact that
the
questions would have been
false
sent
extradition
to an individual
and
does not mean that
kidnapping
that
type of cases.
individual
They
is necessarily
part of
facing an
general
investigation
broad
or is
discretion
being
that the
charged
trial
for that
judge
matter,
has.
because those are formal
In this
processes
case,
as and when,
although
for an
the
example, the
police
police decide
acted
that
gravely
it has got
unlawfully
to be so,
in
to
putting
therefore
this device in the vehicle. They
begin
were
to treat
upfront
people
as far as
as
that is
suspects on a
concerned.
particular
They
matter and so
came
forth.
forward
But
and said, well,
in this
we
case,
did it.
questions were sent because they're
Have a
questions
look
of
whether
clarity
you
and so
want to
forth.
admit the evidence or not.
And there has been a strange
In those
question that
circumstances, the court,
has also been
mindful
raised,
of the fact that
which
the bar for
we find it
permanent
quite
stay is
strange,
very high.
the question of
Said,
timing.
no, they, although a decision
Now, many of
granting
you,
a
for instance, you
permanent
come
stay
from different offices as
perfectly
journalists to this
understandable.
particular venue.
They're not going to interfere
The fact
with
of the
trial
matter is that
judge's,
it is possible that
discretion,
before
even if
getting
this
here,
is a
you
but-for
must have
case.
crossed a red robot
It does not.
traffic line.
It depends in cases
Therefore, it would
of
be strange
this
to expect
category.
that a traffic cop shouldn't give
We're
you
not dealing with trial
a traffic
prejudice.
fine for a traffic
Deals with
violation
the
because you
question
were
of
rushing to this particular
whether
press
the
conference.
interest
And therefore,
in
if that
the
traffic cop
criminal
were to do
justice
that,
system
that traffic cop would have
such an order to
been what?
validate. And they
Complicit
said
in
that
one
is
form or the
tested.
other, or perhaps,
Um,
for that matter,
My lords and ladies will
did
see
not
that
have a
it's some
proper
of the same
calculation around the
judges
question of
who
timing
sat
and so
in the
on,
earlier
because you
Maxwell case,
were rushing to
and
the
they
press
explained
conference. The
some
fact
of
of the
the
matter
things that they
remains
said in the
that
Maxwell
any law
case,
enforcement
where they
agency
seem
deals
to
with
suggest
issues
that there
as they
is a
pertain to a
but-for
particular matter
category
before
cases where
them. And
there
therefore,
must be or there is a real
necessarily conduct what
harm
they need to
the accused
conduct
as a
around
result
a
of the
particular
abusive
area of work and
process.
so on.
Mindful
But
of
also the
fact, of
second
course,
point that I need to make is
previous
that it would
distinction in the latest
be
case at the
incorrect to
expense of the
expect
accused. I said,
that
well,
police
just
officers
because you fall into that category, you're not
must then behave
automatically
like
entitled to a
politicians.
permanent stay.
because they
Broad
can't.
discretion,
In fact,
in
if
your
as a
case,
country were to reach such a
it's
state, for an
50-50.
example, then we must know
But the
that
decision of the trial judge
we are
stands.
heading for trouble
And
in
we'll
the
give
true
you
sense.
that. And also, we will give you
so
the Patel
law
and Early
enforcement
cases that
officers,
we've referred to as well.
they have
And
got to do their
I'll
work
give you
as and
about
when
a
they
2
do
or
it.
3 page summary if you
They
would
conduct
want
it in,
from
of course, in
probably the leading
furtherance of
experts in
the
UK
governing
on this
sort
type
of principles and
case.
the necessary sort of
I think
stipulations,
2 or 3
for instance, in
pages do not
satisfying their work.
infringe copyright.
And that has got absolutely nothing to do with issues of timing. And I think it has been quite unfortunate that that matter has been. It's not an issue of timing. It's what we as politicians can always be concerned about and so on. And that's it precisely because the timing question is also part of a political act or a political tact in one form or the other. So that has been the situation, and I think it's important that we do want to make
it's not necessary that
a call
to show an
that
infringement of his rights. It is in the first place not about his rights.
The question
It
of
is
processes
about the integrity
of this
criminal
nature, for
justice
instance,
We
have got to be respected at all material times.
From the South African jurisprudence,
if there are questions that are being asked, all that is decent and fair for any one of us is to respond to questions.
You will recall that was the 1991 appellate division
for an example, if I'm being investigated for whatever it is that I would be investigated and so on, regardless of whatever I may feel, but the fact of the matter is that process must also be respected. And therefore, I think it has been somewhat unfortunate that some of these insinuations have been made in relation to the work of the homes. Now, it is important for us that we have had to also step out and begin to talk to this issue, precisely because you'll also realize that
overseas
Other than
jurisdictions
ourselves, everybody
and,
else have spoken
cases
on this
where
particular
that has
matter, and yet
happened.
the Hawks do
Some
not
of them
report to
also
themselves.
involving,
They report
South
to
Africa,
the
where
Ministry
we
of Police,
have put
like
people on
the
planes,
rest of the other police establishment and police
allegedly put
structure.
people on
They
planes,
report
and,
there and so forth. So
those issues
it's
are
important for us to
covered.
therefore clarify some
But
of
if
these
I may
issues
just
that
draw to
indeed
your
there is an
attention, if
investigation,
one
and that investigation is
looks
a known
at the
investigation. It has been
policy
ongoing
of the
for some few years
National
now,
Prosecuting
and that relates to
When
the
it
question of the
comes to the
existence of the rogue
factors
unit.
that
And therefore,
you
various
consider,
individuals, of course, will be questioned from time to time,
they don't
particularly
even mention
when they were
the
either in
strength of
proximity
case.
or
And there's a
when they
reason
existed
why.
and functioned
Because strength of
at a
case is
particular point
presumed.
when these
If you don't want
particular
to prosecute somebody
matters
because you have doubts
when
about
these
whether
particular
you've got
matters
strong
arose
case,
between July
decide not to prosecute him
2009
on that ground.
to
But
let's
if
say
you
2014
consider
for an
that there
example.
are sufficient
But
grounds
lastly, as
on
I
the
had said,
facts
that
for and evidence for
ourselves, the
prosecution,
police, the Hawks,
then
we got
we look
activated
at the
on the
other
basis
factors.
of a
Mindful
complaint
of the
that
fact
was
that you've got strong case.
lodged with
And that
us
is
in
why
May
I have put the
2015,
proposition
and therefore
also
started
to
conducting
my lords and ladies
these
that
investigations.
indeed,
Thank you very
at
much.
the stage that you get to the policy factors and
we'll
the
take
integrity
questions.
of the criminal justice system, it is no longer really.
I'll start with Marianne, as usual.
I'll start with
Marina.
the case against the
1,
accused.
2,
You assume
3,
that you are going to
Gay, Carol,
And since we are talking
and-
about policy,
Marianne. Okay.
I'm looking
So I'll
at
take
the
6
fact
at
that
a time. Thank you. Marianne.
on the
Marina Lamprecht from Network 24. I want to know, why did the
Statement
Hawks tell Minister Pravin Gordhan not to speak to
allegations which says
witnesses
that Chapter
if
4,
he is not being investigated
Paragraph
himself?
6 of
Can you
NPA
confirm that
policy
he is not being
directive provides
investigated? I know you keep saying the
Where the
unit is being
prosecution is
investigated, but is it
confronted
possible to investigate
by
the
opposing
unit and not
versions,
Minister Gordhan?
you
And
should
then
refrain
if you are
from
investigating him
making
on what
credibility
offence and
finding
by
based
what
on written
authority,
statements,
what
and should
authority are
rather
you relying on
refer the matter to
to put
trial.
these questions to him? Thank you.
what do you say about this? Because in the case before us, there are opposing versions.
Thank you, Jan Anibal, for the Sunday
As to
Times.
the conduct
Minister
of,
of Police, you keep referring to the rogue unit
McCarthy
by that
and
name.
Luka.
Does that
Luka
mean
said
that you
no, everything
underwrite
was done
that
in
description
good
of the
faith.
unit, which is
So
not
was
being
it
used
not
by
better?
everybody? Secondly,
As it is
in what
stated here
format
that
did
it's
Minister
reflected in the
Gordhan
policy
receive
that the
these
matter
questions?
should
Thirdly,
rather
has he
be
answered
referred
them?
for
I think
trial so that
today
the
is the
court
deadline
can
day.
deal with these issues
Fourth,
in detail.
he referred to some
Can I first
people who
give
are
you
interested
what I
in
would suggest
undermining
would be the technical answer to
institutions.
your question.
Do you feel that
And
the
that
Hawks
is,
are
how
among
is that
those
going to
units
be
or parts of society
before
that he was
the court
referring to?
from the NPA
My
side?
penultimate question, there's
If
a
they can't bring
very,
it before the
very
court as
strong
part of a
impression
criminal case,
that this is a matter of the President
it is
versus
not
the Minister of
That is
Finance.
not a list. And if you look at the
What do you think that kind of
freedom
impression
under law
would
case,
mean to our country and whether it
Judge
might be viewed as a
Blunt says
banana
that.
republic
he
and
says
come into
the
a
decision
ratings
to
downgrade
prosecute
position?
doesn't form part
Finally,
of the trial proceedings before the court.
Do you, Minister
That's
of
why
Police,
you can
and
bring
do
a
you,
separate
Minister of
application for
Intelligence,
that. It is,
back the Hawks in this, or do you
I
not?
mean, if we started a criminal
I
trial
thought he's finished all the
and
questions.
we put everything in dispute, the prosecution
Good
would
afternoon,
call
Craig
its
Dodds
first
from Independent
witness. It would not
Newspapers.
call,
I suppose either of the
Mr.
ministers could
Newcomb.
answer this question. The
There's
equipment
no way
that you've
that they were
listed,
going to call
is
it.
it illegal to
And
buy, possess
how
or sell
is he
that
going to
equipment?
get into witness
And if
box and this
so,
resolved
where did this official buy it
unless we
from and
decide
how?
to bring a permanent stay?
And then if you could also say
How does
what
that help
charges
the
are that you're
NPA?
investigating and in terms of what legislation.
So that is from the technical side. From the other side,
Just with regards to the procedure,
evidence before you,
if what
there
happens
is
in the
no
event of
evidence
Minister
on
Gordhan
oath
not answering
to
the questions
say
immediately, I mean, is there,
that,
again, following out from what
the
my colleague Jan
inferences
said,
drawn by
our
the
understanding is that today is the deadline,
NPA
the suggestions
and
that he
by
won't be
Mr.
able to, so then what is the
Hofmeyr and by
procedure if he
Mr.
doesn't
Mashid,
answer,
and
let's say
in
by
fact
today,
by
then he
Mr.
has
Downer,
a week or 2 weeks in which to answer, failing
as
which he
to
will be
what
subpoenaed, you know,
was
what is the
intended to be
legal procedure
between Mr. Mukam
going
and
forward
Mr.
in the event of Minister, there's just a sense of
had
deja vu.
any
Also, one of the questions of the political ramifications or intrigue, or for lack of a better word. a few years ago, not last year actually, when you were here, you presented a very comprehensive statement on Kandla. Subsequently, that was found to be sort of, dare I say, incorrect. So to what basis do we, how do we treat what is being said here with the necessary veracity and credibility, given the fact that previously that has been undermined? I mean, how do we know that you are, just to be blunt, are not acting at the behest of the President?
With somebody outside the National Prosecution Authority.
Thanks, Gay Davis. Eyewitness News. I'm largely covered by my colleagues, but I'd like to just go back to the issue of credibility. Following on my colleague's last question, just given the appointment of Major General Burning Lemeza as the head of the Hawks, and whether you're confident that there can be wholehearted sort of perceptions of his credibility, given what the judge had to say about his integrity and the fact that he lied under oath. The narrative around this being that people are leveraging political support to make personal profit, and that there is essentially a proxy war underway between forces that want to capture state institutions for their own bottom lines, against people who are doing what they can to defend the sovereignty of those institutions for the good of the country. And following on my colleague's reference to your defense of the eNCA spending and how that turned out for you, Minister, how can we sit here today and believe you? Thank you.
Thanks. It's Carol Payton from Business Day. Minister, if the complaint was made in May 2015, why has there been so little progress at this stage? Secondly, what is the complaint exactly, and what are the charges that you're investigating against who? And then going back to the establishment of the unit, as you said, it was originally supposed to be in the NIA, and then it was, that didn't happen. But was there not a cabinet decision to establish the unit in SARS, or was there no such decision? Thanks.
Is indeed a separate legal act from the decision to discontinue charges. It may well be that the one informs the other, but that issue was not raised on the papers, and it was not part of a release.
About it that is illegal, or do you know the individual who procured it for what? And just also to point out that the terminology of rogue unit only became used after it had been included in stories that the Sunday Times published after a leak. Before that, there was absolutely no reference to this, including in the Sikhakhane report. And the terms of reference of the Sikhakhane report were changed after the media leaks that there had been a rogue unit, and there's a dossier that existed by former members who had been suspended from SARS. So the actual terminology rogue unit comes from a dossier from those, and only entered the public domain much later than April, you say. And then the terms of the Sikhakhane report were altered to include that. Could you just answer to those questions? But my colleagues have asked the other questions. Thank you.
The court would have said, well, what's happening
from the SABC Radio News. I just want to know, Minister, who is the complainant? Who was the complainant of this? And how did this complaint come about?
But our situation is being reviewed. The court would say, well, what has that got to do with me?
Let me start perhaps with the last question. Who was the complainant? The complainant was SANS. That laid a complaint on the basis of the information that surfaced at the time with the South African Police Service.
How a judge would deal with a lingering thing.
I find it strange that the question of
you're on bail, you must
what
report,
authority do police
you don't
have
report, you must
to
come report on
investigate
this day,
arises.
Why? There's absolutely
Now,
no reason why.
the work of the police is
these should
governed
be put through
and
that.
is dictated to by
So,
the constitutional mandate. For an example, we investigate crime
Was he scheduled to appear on the
wherever
8th?
firstly it exists.
In the normal course of
But secondly, we also do follow up and investigate on specific sort of complaints.
On the 8th.
Now, and that jurisdiction is a nationwide jurisdiction that the police service
no one brought an application
has got. So I find it a very strange question that what authority does the police service, for an example, or even Hawks for that matter, have in investigating a matter that would have been brought to its attention.
An application as soon as
the terminology rogue unit, I accept that that's not the formal term, but it's what it has been commonly referred to. And for better, probably, consumption and understanding, I suppose, we also get caught up in referring to it as the national, as the rogue unit. It started off as a national research group, and then it changed, it became a national high-risk intervention unit at some point, and so it goes. But as you say, and correctly so, after the media exposés about the existence of such a unit, it kept on referring to it as a rogue unit.
Asked the NPA, when are you withdrawing charges?
The gentleman refers to a perception that it's the president versus the minister of finance. And I'm happy that you use the term perception.
As interim
because it is perception.
Don't want the charges withdrawn
and perception can't be fact and be factual unless you establish that as a fact and so forth.
You against such a
so I do not know where indeed that comes from.
But may I say,
if a unit such as the Hawks or any other police unit, for instance, conducts its work and does its work, I do not know why it would then have to be lumped together with this picture that has been created, for an example, of either the Minister of Finance against the President or the President against the Minister and so forth. It just doesn't exist. And I think let us also not forget that that matter itself has also been clarified. In fact, there have been statements issued in regards to the same issue of perception that has been created. Is the equipment illegal? I think it was Mr. Dodd's question.
You could bring them again.
Are you Mr. Dodds?
You will see in...
Okay, thank you. It's because we also have a Dodds somewhere in our office.
The court says that, in fact.
So it's whether the equipment is illegal and so on, and so it goes. And in this regard, I may want the Minister of State Security to talk about the issue of equipment and the issue of because I think it's also related to the issue of competency, for an example.
Refund of bail, all those issues are concerned.
Okay.
Those are the normal consequences. And
the format around questions, I mean, really, the format around questions, you compile questions, you submit questions and say, look, these are questions of clarity. And that's basically that.
But because somebody has taken us on a review, you must come back in a couple of months
strange question. What charges are you investigating? How do you investigate a charge?
That is not how a court would have dealt.
Because the charge
is
probably
and that is
just
not covered by
about the final product. And I'm not saying the final product.
The only point
you can only be charged once an investigation would have been conducted. So you start with an investigation. If your investigation leads to a situation where perhaps there are issues to be answered in law, for an example, and that's where the issue of charges there does come in. So I find this thing strange. It's in reverse. I mean, how do you investigate a charge? What charges are you investigating? it's that's I think that's really a skewed way of and what legislation are you using? Again, it goes back to the first question that I'm saying. It's a strange question in a sense that the South African Police Service is governed by both the Constitution as well as the South African Police Service Act to conduct their work. So. And that's a known fact that it is within that particular sort of framework that the police service at all material times has got to function.
If you say they did not consider them properly for some reason,
the gentleman in the front talks about deja vu in Gandla and so forth.
That is what must happen.
Firstly, there's no... And you say that report has been, what? Did you say set aside?
Your argument.
You said it was found to be what?
Notice of motion. That the notice of motion is silent.
Who certified?
In respect of the charges that have been withdrawn.
Who certified?
So what?
Who certified
what was the problem
that report
in the case
to be invalid?
If my lord simply say, if you find for the applicant that decision is set aside, so be it, then they got what they asked for. But that's
you're also incorrect insofar as that is concerned, because the issue of the report released by the Minister of Police was not a center of a contestation, for instance, before the Constitutional Court. You started off by saying it was found to be invalid.
You can't extend it to something that you did not ask.
But that's what I heard. I'm sorry if I
give my lord for analogy of what I have
incorrect. It was never found to be incorrect by anybody.
Asks for a tender
there's also no judgment about that report. So you can't say it's incorrect. You can't say it's invalid. You can't even say it's irrelevant.
Whether the contract concluded pursuant to the tender is set aside.
That report is correct.
So the decisions
and I've been saying this particular point, for instance, that
if one does not follow the other,
the approach with regards to the work that we were sanctioned by Parliament to do with regards to the issue of security versus non-security issues at Tingandla and so on was a research approach, and that's what happened.
The contract has gone so far, I'm not going to set aside.
So are you suggesting
if you've
that
got to refute or dispute that particular report, the one requirement is that you must conduct your own research, for an example, to therefore disprove and refute the report, the issues that were established in that very same report, for an example. And that's what hasn't happened in this country. That's fine. Perhaps at some point it will happen, I don't know.
That is not an issue before you.
The fact that
because that is not the issue.
Some legal issues arose before the Constitutional Court, for an example,
those issues would be
and were argued and debated in the manner in which they were debated and argued.
Ourselves too much with them.
That necessarily should not be conflated together with the fact that there is a report that the Minister of Police had to produce on the basis of the resolution by the National Assembly, for an example, to conduct some work in that regard. If that report is to be refuted in any particular way, there has got to be a process that also would have to be embarked upon to deal with that. The issue of credibility, and this thing has been, oh yeah, by the way, there's also the issue of credibility. How can I now be, I think it does fall away, sir. You would agree with me. How can I now be trusted in terms of what I'm saying and so forth? I think your question does fall away in a sense that we now agree that that report, there hasn't been any judgment against it. It hasn't been set aside. It hasn't been found to be incorrect, for an example. Until there's such an exercise that arrives
check with the stenographer.
Then
can you record properly? If Mr. Omar is standing there, would you prefer that he comes clear? Is it fine? Okay, you may proceed, Mr. Omar.
As you please, the court, the Justice Leguama. Mr. Justice Leguama, and of course the other justices, the applicant summarized its relief it is seeking in this proceeding on page 434. But let me do this, Justices. Before I continue, Mayor, please ask judges to allow me to hand up a document headed oral submissions of amicus reduced to writing. This will be very helpful for the court to follow my submissions as expeditiously as possible.
Well, on the document sent to us when we requested the time schedules of the arguments, it was noted that you'd address us for 15 minutes. Is it still the case?
No, in my practice, I said approximately 1.5 hours. But I will ask judge to give me 45 minutes. I'm confident I will be finished in 45 minutes. With judge.
Understanding of just basic understanding of what the law expects is that then in that case John Ntlemezo should have been faced with the charges pertaining to perjury, for an example, which of course in this instance can't be precisely because there wasn't a particular finding or ruling in that regard. Now
I'm told that
let me ask the Minister State Secretary to deal with the question of what is being referred to as equipment, whether that equipment is illegal or not illegal.
Placed properly, or maybe you can move closer to the microphones that have been set already.
Firstly, we get to be drawn to the matter, those who knows, because we've been writing about it. 2014, well, it was not Sunday Times in our case that drew us to the matter. We were thrown in by City Press to say we are destabilizing SARS. We acted, those who sit in our Joint Standing Committee on Intelligence, they will know. We commissioned an investigation by the Inspector General of Intelligence, and she did actually come to findings, and we reported back that we never did any destabilization like it was being purported in the papers. Well, unfortunately, we'll never get an apology on these matters. But what we could say is that the matter is subject of an investigation now. And because there's an inference about our involvement, we are cooperating.
answer to this question he raises himself. Why? Because the NDPP conceded it. The NDPP agreed that these decisions are reviewable. Which decisions? Specifically the decision by the DPP to discontinue prosecution. I want to emphasize that the applicant, no litigant before the court, have even murmured that Judge Brandt erred or was wrong. My submission would then be that accepting stare decisis to be the doctrine in our law today, the findings of Judge Brandt are binding upon this honorable court. Binding for one of two reasons. Either it's stare decisis or it is obiter dictum. As far as the finding on the question which Judge Brandt asked and answered in paragraph 19, I submit it is obiter, but still binding. It's obiter because the question which learned Judge Brandt raised, the NDPP conceded to. Judge Brandt now continues. He says, I'm dealing with the answer of this question on a very narrow basis. Can a decision to discontinue a prosecution be reviewed? That's the question. Okay. Judge Brandt says, I'm dealing with it on a very narrow basis. Judge Brandt deals with extensive English authority. Why English authority? Not because we are surrendering to the former colonial masters, no. We were ushered into New South Africa, Codesa is there, our constitution is there, it's a product of an agreement, Ubuntu, we settled, we are here now, good. The position in our law, as far as the National Prosecuting Authority Act is concerned, resembles almost identically the position in England. The difference I noted is that the Crown prosecution in England is the NDPP in South Africa. Now, what is the relevance of this? On page 308, judges, at paragraphs B-F, Judge Brandt quotes English authority with approval. I emphasize. In paragraphs B-C on page 308 of the full judgment, Judge Brandt, with approval, says the following. The power of review is one to be sparingly exercised. The reasons for this are clear. The primary decision to prosecute or not to prosecute is entrusted by Parliament to the prosecutor as head of the independent professional prosecuting service, answerable to the National Director of Public Prosecutions in his role as guardian of the public interest and to no one else. Now, Judge Brandt endorsed, approved this view in answering the question the learned judge raised himself. But before I continue, I want to emphasize that South Africa is a constitutional democracy. We are no longer subject to parliamentary sovereignty. Having said that, I continue. Then, Judge, in paragraph D-E, Judge Brandt, with approval, says the following. From all those decisions, it seems to me that in the context of the present case, this court can be persuaded to act if and only if it is demonstrated to us that the Director of Public Prosecutions arrived at the decision not to prosecute Upala. Judges, what do we have here? We have a pronouncement binding upon this court that this honorable court can only interfere and set aside a decision on review to discontinue a prosecution if that decision to discontinue is made by who? The Director of Public Prosecutions. In this case, the DA, the applicant, has not even attempted to demonstrate, and in fact is expressly relying on an alleged decision to discontinue prosecution made by who? The National Director of Public Prosecutions. My submission is, Judge, the court is bound. If my submissions in this regard are upheld, this case is over. We do not have to further endeavor to facilitate the objects of the applicant to have this court pronounce on phantom divisions within the leadership of our ANC on the verge of an election. That's it. Having said that, I will continue. Assuming by some stretch of the imagination my submission in this regard is not accepted. Judge, what is being sought here? What is being sought here is, as I've quoted, a review of a decision made by Advocate Amshe SC, who the applicant alleges set aside a decision of Advocate McCarthy. Advocate McCarthy at the time was the deputy NDPP. Now, where does and how can Advocate Amshe, the NDPP, set aside the decision to prosecute made by Advocate McCarthy? Only one. And this appears in section 179, 5D of our Constitution. Section 1795D, judges, provides the following. The National Director of Public Prosecutions. Now I want to emphasize, our law makes a very clear distinction between the National Director of Public Prosecutions, the Director of Public Prosecutions, the Deputy Director of Public Prosecutions, and the Deputy National Director of Public Prosecutions. This clear distinction made by our law is found in Section 20 of the National Prosecuting Authorities Act, Act 32 of 1998. I'll elaborate, I'll come to that shortly. But on the point I am now, my question I asked is, where does the NDPP get the power to set aside a decision made by the Deputy NDPP? Section 1795 provides that NDPP, we go to D, may review a decision to prosecute or not to prosecute after consulting the relevant DPP. Let's examine that. Judges may review a decision. What is a review? A review is conferring the power merely to confirm the decision made by his subordinate or to set it aside. Okay? Look, with respect, Paja, Section 8 of Paja provides that even a court on review can't substitute or vary the decision. On review, the decision must either be endorsed, confirmed, or set aside. Upera, nothing more, nothing less. Okay. Now, what is Section 33 is the broad provision in the Constitution protecting the public's right to fair administrative action. Paja Act 108 of Paja Act 3 of 2000 was enacted in deference to Section 33. That's right, that's common code. Now let's examine this. Let's go to Section 8. Section 8.1 of Paja Act 3 of 2000 provides the following. Remedies in proceedings for judicial review. The court or tribunal in proceedings for judicial review in terms of Section 6.1 may grant any order that is just and equitable. Now, if indeed Advocate Amshe did set aside a decision made by Advocate McCarthy, it is clear in terms of Section 8.1 that what will be required of Advocate Amshe is an order. Okay, once Advocate Amshe makes an order, the DA, the applicant, comes to court and asks the court to review that order. We were here for 2 days now. Neither the DA or anyone else in this court once uttered the word that this court is asked today to review an order made by Advocate Mshe. The decision is made by the subordinate, either the Deputy NDPP, the DPP, or the Deputy DPP. That's Section 20 of the National Prosecuting Authorities Act. Now, I'm saying with respect, one, this court today does not have the jurisdiction to review the decision which the DPP, the applicant, wants this court to review. Why I say so? One, I rely on Learned Judge Brunt in the full case. Learned Judge Brunt says a judicial review in court can only take place if the applicant in this case shows the court that the decision to be reviewed is the decision of the DPP. Number two, I further submit that this honorable court does not have jurisdiction. Why? Because the announcement, the expression, the opinion, call it what you want, made by Advocate Mshe, broadcast live on national TV, can never by any stretch of the imagination be elevated to an order. No order. This honorable court can only review this matter in terms of Paja. Paja requires an order. If it is suggested that this court is doing the review in terms of the principle of legality, applicant must fail again. Why? Because guided by the principle of legality, this court can only review the decision made by the DPP. That's my submissions on the issue of jurisdiction. Judge, and then I will refer the honorable judges to paragraph B. Judges, I want the court to have regard to section 20, 1, 2, 3, and 4 of the NPA Act. This act and section 20 gives exclusive powers to make decisions to inter alia discontinue a prosecution. These powers are exclusively given to the Deputy NDPP, the DPP, or the Deputy DPP. And then section 22, Justice Mortley raised a question to my colleague Advocate Epstein. The question raised by Justice Mortley was the following: why didn't Advocate Mshe take disciplinary measures against Advocate McCarthy? The eloquent, correct answer given by my learned friend Advocate Epstein SC was the following. Advocate Epstein told the court that it's only the president who can dismiss an NDPP or suspend him. And that's the reason given to the court why Advocate Mshe did not take disciplinary measures against Advocate McCarthy. Judge, what Advocate Epstein eloquently conveyed to the court is an answer which he gave, which is genuine and true. These proceedings here must adjudicate upon the bona fide conduct of Advocate Mshe. Now, section 22 of the National Prosecuting Authorities Act unequivocally says that the NDPP will have authority over the Deputy NDPP. Okay? That authority, our jurisprudence in this regard is still growing. I submit it could be argued that that authority contemplated by section 22 will include starting disciplinary measures against Advocate McCarthy. That must still be dealt with in a future upcoming court. The point I'm making as far as my submissions are concerned, it's section 20, read with section 22 of the National Prosecuting Authorities Act, clearly delineates the powers of the NDPP, the Deputy NDPP, the DPPs, etc., and lower down. Judge, the NDPP does not have the power to make a decision to discontinue a prosecution. That power is exclusively given to the Deputy NDPP and the DPP and below. The power given to the NDPP is one of authority and one of review contemplated by section 179. Then, Judge, before I continue, I must emphasize the following finding in freedom under the law. Judge Brandt, on page 305, paragraph 19, quotes Constitutional Court authority. He says, found by the Constitutional Court, our Constitution contemplates a single system of law which is shaped by the Constitution. To rely directly on Section 33 of the Constitution and on common law when Paja, which was enacted to give effect to Section 33, is applicable, is in my view inappropriate. It will encourage the development of two parallel systems of law, one under Paja, another under Section 33 of the common law. Who is asking this court today to develop two parallel systems of law? Who? That which the highest court in our land, our Constitutional Court, has described to be inappropriate, the applicant. The applicant is known to boast it wants to enforce, uphold, and respect the Constitution. Here's a case today before this honorable court. The applicant wants and is asking this court to contradict and to asking this court for an order that will emasculate the sanctity of what? Of that which ushered us into a peaceful new South Africa. At this point, judges, I want to say that the principle of legality was reluctantly introduced into our law. In the same judgment, Judge Brandt found that a decision not to prosecute and a decision to prosecute is the same thing. Judge Brandt said so with reference to Section 1FF of Paja. I want to emphasize that this reliance on the principle of legality cannot be used for every decision that is made which Paja does not make reference to. It is circumscribed very narrowly to only a decision to discontinue a prosecution made by a DPP. So any suggestion, various political groups say, I will rely on the principle of legality, XYZ. No, we are a constitutional democracy. We have to respect our constitution. There are some decisions which are in the sole preserve of the NDPP, others in the sole preserve of the President, others in the sole preserve of the National Assembly. Judges, the applicant alleges, and those who allege must prove, that applicant Mshe made a decision that purported to be in terms of Section 1795B of Act 108 of 1996, i.e. by setting aside the decision of Advocate McCarthy and ordering that prosecution against the respondent be stopped. Now, in submitting what I'm submitting, I am not detracting from my submission that this honorable court cannot review a decision. This honorable court can only review an order made by the NDPP exercising his powers in terms of Section 1795B.
You've made it a submission, and you are saying it did not make an order. Are you also saying that the decision by the DPP stands because there's no order?
No.
Just answer me on that.
No, I'm not saying so. I now make the submissions on the following. I'm submitting that if the court finds that there was an order, or if the court says there's no order, now I want to answer this very question raised by Judge Redwawa. What if it is a decision? But before we go and determine whether it is a decision, let's see if Advocate Mshe made any decision at all. I want to show this honorable forum, this honorable court, that the applicant who bears the onus has not given one semblance of evidence that Advocate Mshe in fact made a decision in terms of Section 1795B. I want to show the court that a decision, it is not me who's alleging it. The applicant does not say stop a decision. I want to review the decision of Advocate Mshe made on this date in April 2009. No, the case before the court, the notice of motion is not amended. The affidavits are not amended. The applicant says its relief it is seeking today is to review a decision made by Advocate Mshe to discontinue the prosecution of the Honorable President Zuma. That's what is being sought for. Okay. I'm going to show the court now that the applicant has failed to allege, and in failing to allege, applicant has failed to prove that such a decision that it wishes to have reviewed has ever been made. Why I say this is the following. I refer you judges to page 4 of the oral submission reduced to writing. The reasons hereunder debunk the applicant's submission that Advocate Mshe SC made a decision to discontinue prosecution of the third respondent. Judge, the powers given to Advocate Mshe are exclusively the power to review. Nowhere in any law is Advocate Mshe given the powers of a court to vary or substitute the decision that he would be required to either confirm or set aside. Our courts are given this jurisdiction in terms of Section 8 of PAJA, which says only in exceptional circumstances may a court substitute or vary the decision of an administrator. Advocate Mshe is not. Now, Advocate Mshe's power to review. What is the law that Advocate Mshe must be guided by or is prescribed to follow in making the review? Advocate Mshe, as I've shown the court from Constitutional Court Authority, can only do a review in terms of PAJA. Okay. Page 5, paragraph 2, Judge. Applicant does not even disclose the identity of a person who instituted a review. An indispensable requirement to trigger review is set out in Section 6.1 of Act 3 of 2000. Now, Judge, I showed the court clearly that the review today, which the applicant is asking for, it cannot ever be based on the principles of legality. Why? Judge Brown says it is only the decision of the DPP that can be reviewed in a court of law, not NDPP. Now I suspect the applicant will tell the court, guarantee million%, no, we are here in terms of PAJA. I say with respect, no. If you're here in terms of PAJA, then an indispensable requirement for you to follow that's peremptory is compliant with Section 6.1 of PAJA. Where is that compliance? From whom did the DA ask reasons? If the DA asked reasons to Advocate Mshe, the Honorable Advocate Mshe SC, but very nicely, politely, address him properly, Advocate Mshe SC, dear sir, Ray, decision made on blank date. We wish reasons from you to give us why you have decided to discontinue the prosecution of the Honorable President Zuma. Now, if the DA did that politely, very politely and courteously, I reassure you, Advocate Mshe would have sent a response. So, firstly, I made an announcement. Secondly, I made no order in terms of Section 179. Thirdly, you say I did wrong. Okay, if you say I did wrong, I could give you advice, which I'll come to shortly, but you do what you have to do. Section 6 or Advocate Mshe could have politely told the DA, gentlemen, guess what? I agree with you. You say the procedure I did was wrong. I'll do it correctly. But compliance with Section 6.1 of PAJA is an indispensable ingredient to properly obtaining a relief in terms of PAJA. I want to emphasize PAJA, that's the protection of the Administrative Justice Act, was enacted in deference to Section 33 of our Constitution.
Mr. Omar, I see you are on page 5 and in your oral submission to page 12, and you are left with 10 minutes. I've given you 45 minutes.
Judge, no compliance with Section 6 of PAJA, no compliance with Section 8 of PAJA. Then I continue, no person was able to institute such review proceedings. This is the most important, Judge. Judge, I submit no person was able to institute such review proceedings. Which review proceedings? The review proceedings in Section 179. Simply because there remains no procedure even today prescribing procedure to institute review proceedings in terms of Section 179. Rule 53 is the vehicle of procedure required for a review in the High Court. Judge, in R versus Killick, 2011 EWCA CRIM 1608, this is decision from English authority, found that the right of victim of crime to seek a review of CPS, Crown Prosecution Service, the equivalent of our NDPP, not to prosecute are the following. 1, a victim has a right to seek a review in such proceedings. No question about it. A victim has a right to seek a review to a decision, not to discontinue a prosecution. Who's a victim? We have to establish who's a victim. The offences dealt with in English law, assault, rape, murder, etc. Whether the DA is a victim, if the DA says we are a victim, we are a member of the public, my submission is please submit to democracy. Majority don't believe a sitting president should be prosecuted. A victim should not have to seek recourse through judicial review. This is the latest case on point in the UK. Many cases were given to the court. This, I emphasize, I want to impress upon the court, is the latest authority from England on point.
Will you give us a copy?
I will try, Judge, but...
please make a copy available to us, because you should know that when you refer to a case...
I'm arguing for the frame. Thy frames thy head and the adoption inclined. Grapple into your soul, the hoops of steel. I will ensure it gets to your register, Judge. Thank you. A victim should not have to seek recourse through judicial process. In England, it is said, a victim who has a right to review does not have to be forced to come to court. Victims' right to review should be made subject to clear procedure and guidance with time limits. Now, Judge, we are 21 years into New South Africa. But this position took about 40, 50 years in England. We are here today. I will ask the court, number 1, dismiss the applicant's application. The costs I'll address later. But I'm appealing to this honorable forum. I want the court in its judgment to emphasize the importance of the NDPP to please get moving. Make the rules for the procedure. You can't give a person a right in terms of Section 179 to review a decision not to prosecute and not make accompanying rules. We need these rules. So if the court in its judgment spells out as they did in England, in UK, we need real rules of procedure. Then I will recommend to Sean Abrams, the NDPP, amongst the rules will be the following. Number 1, a sitting president cannot be criminally charged. Neither can a decision to discontinue prosecution against a sitting president be entertained. Number 2, a president who has served a term in office, completing his term in office, can under no circumstances have subject to review a decision to discontinue prosecutions against him for actions he took before he became president. 2 rules I've suggested today. Applicant, I submit, misleads this honorable court by suggesting that applicant Mshe made a decision in terms of Section 179. Judge, to summarize this point, I am showing the court a decision. Advocate Mshe could not make the decision or order in terms of Section 1795D as alleged by the applicant for the simple reason that there is no procedure. It's impossible. You know, if I may use an analogy, I'm saying please get to destination called Kathmandu. There's no road built to Kathmandu. How can it be suggested that Mr. Vauda, the secretary, went to Kathmandu? There's no road. And we can only get to the place by road. Impossible. Then I submit that Section 5 is also a necessary ingredient to invoke successfully the relief suggested, contemplated in Parliament. Section 5, Section 6. There is no allegation that there was compliance with Section 5, 6, or 8 of Parliament. These are necessary allegations which the applicant was required to make. It's nothing of the sort. I mean, we in motion proceedings, if you allege there was a decision, I've shown you this is out, but in any event, if you allege there's a decision, Mr. Applicant, you must prove it. In motion proceedings, you allege and prove. But if you haven't alleged these essential ingredients, how can you say to have proved it? Impossible. I've sufficiently addressed judges on my submission that this honorable court does not have the jurisdiction to grant, I want to emphasize, to grant the relief paid for by the applicant in this case. Never. Judge, I want to emphasize on this point, these are my instructions. Suggestions to the contrary undermine the supremacy of the South African Constitution and the sanctity of the principles of separation of power. Judge, you know, in Kudesa, we struggled. The previously privileged wanted certain protections. We agreed. Ours was not a military victory. Our country was a negotiated settlement through the sacrifices of Madiba and President Zuma was the head of Mkondo. They sacrificed their lives for us. The principle of the sanctity of the separation of powers to us is as sacred, or could be as sacred as the Quran is to me. We'll die for this. The independence of the judiciary, the executive, the prosecuting authority, and the bureaucracy must remain firmly independent. What is shocking is that the applicant who purports to want to uphold democracy, uphold the Constitution, wants this court to do the contrary. This, Judge, is analogous to asking the Constitutional Court, which happened recently. There was a case in the Constitutional Court, and a counsel asked the Constitutional Court to pronounce or make findings involving a phantom, non-existent impeachment proceedings. How can the Constitutional Court or any court make findings about impeachment proceedings which are the exclusive preserve of Parliament? So this is the extent which the applicant wants us or wants to contaminate our law, our jurisprudence. So we should move into an era where we have no more distinction between separation of powers. What's the aim? The aim, ultimately, govern the buggers through the courts. That's the aim. That will not happen. That will not happen. Judge, furthermore, I emphasize, if the majority of the electorate were unhappy about the discontinuation of the proceedings against the Honorable President Zuma, such dissatisfaction was clearly not manifested in 2 democratic elections, resulting in Honorable President Zuma serving his 2nd term as President of the RSA. The most recent attempt was yesterday, a vote of non-confidence. Applicant attempts to distort the SA Constitution. I want to emphasize, the applicant attempts to distort the South African Constitution, which is sacred to the hearts of the stalwarts of the struggle, by undermining the will and intellect of the majority of South Africans. Mine too. This is startling, as there is no democratic country in the whole world with an official opposition attempting to have a sitting president prosecuted, even before ending his term in selflessly, and I want to emphasize, very stoically, serving the majority of the people. President Berlusconi, they tried it. The court ordered, the highest court in Italy ordered, you can't prosecute him now, wait till he finishes his term in office. But the goal to come to the court and to add burden to our president, good Lord, what is serving in office? What's the purpose? Judge, now, with respect, the proceedings in the KwaZulu Natal High Court.
Mr. Omar, your time is up. Please summarize your submissions.
I'm the last page.
Okay.
Judge Motley and Judge Ledwaba asked the question to my learned friend, Advocate Kim. My instructions are that in Pietermaritzburg, KwaZulu-Natal High Court, when Honorable President Zuma was called as an accused, the state asked for a postponement. The learned judge who was presiding at the time, Msimang, refused the postponement. Judge Msimang looked at the prosecutor did nothing. Judge Msimang then struck the matter off the roll. So that is the state of the proceedings against the Honorable President Zuma. It's not an order or a decision to discontinue proceedings, it's the striking the matter off the roll. Right. Now, I will tell the DA what to do. And they do it, I'll bring them again. What the DA, the applicant, ought to do is the following. Bring an application for a mandamus to a letter to the NDPP, Sean, say the case is pending, pa. The court struck the matter off the roll. You must set the matter down. If the NDPP refuses, the DA eagerly brings a mandamus to compel. Court may grant mandamus. Court grants mandamus, and all these arguments here will be dealt with in the KwaZulu-Natal High Court. How can this court be asked to interfere in proceedings that are pending? The issue that must be answered today is what is the status, what is the effect of a striking out order. In conclusion, Judge, if this honorable court agrees with me that the sole motive of the applicant is to extract a pronouncement of adverse infighting within the leadership of our ruling party, the time has come for us to send a message loud and clear to the applicants. Stop it. Stop interfering with the Constitution, and therefore I'll ask the court, if the court agrees with my submission, make a cost order today on the attorney and own plan scale, jointly and severally, they only is pro place against the applicants. First warning today. Next warning will be something else. Malema become president. Who knows after 100 years? But all, another a firmer warning. Okay. Thank you, Judge.
Thank you, Mr.
Thank you very much, Judge.
Anything? Any questions?
No.
Okay. Mr. Rosenberg, surely you need to reply. Can you give us an indication as to how many hours are you going to need with your reply?
I would welcome an opportunity to commence the reply tomorrow.
Yeah, it will definitely be tomorrow. We just wanted to have an idea of how long.
Reflecting and making it brief, I certainly don't anticipate that I would be much longer than an hour.
Thank you very much. I think we'll adjourn and then...
Sorry, Judge, yes. Judge, I have a medical condition. My feet get very warm. It's being aggravated. Will the court excuse me from tomorrow's proceedings? I'll ensure a representative of my client is at court.
No problem. Yes, you'll be excused in respect of tomorrow's proceedings. So the court will adjourn. Will start again tomorrow at 10 o'clock. Thank you. Court adjourned.
No, come here, my friend.
I'm not a judge. If I'm a judge, I'm dirty by now. This kind of question. Thanks God, I'm not a judge. Where does that end? This guy is throwing everything in all directions. Hi, Siabo.
Look,
You think this boyfriend will agree? Just hijack them because... Which it's only these people. I think they were trying to make them and then they park it on other side. Now, just for this week. Pretend as if you don't know because it will turn out to be some sort of for now, yeah. You guys, they are sabotaging us, they are discriminating.
No, but you know, I would see learners in 7th Avenger. These people have got a very serious matter. And it is the truth of God. Mahamba